So we're going to start our workshop today. Welcome everyone here today. I am Rich Shapiro. I'm a partner at Blustein, Shapiro, Rich and Barone here. In our building we have this education room. We also have the entire top floor, and then outside here is our mortgage department. To my left, your right, is DuBois, and also with us is another attorney, Megan Conroy. So the three of us, in conjunction with three team members, constitutes the elder law and estate planning department of our law firm here. We have 16 attorneys in total, and we do a lot of different things, and our practice area that we focus on is estate planning, elder law, and business planning. So the workshop today is fairly lengthy and comprehensive, and we're really here to answer questions for you as you have them. And by all means participate so that we can learn from you and you can learn from us. A few housekeeping items we have. Today we have, everyone should have a folder here. And in this folder there's a lot of information. One thing you may want to, you already have that out, is the PowerPoint presentation that we're going to follow today. There are other articles throughout the folder that will be useful for you at either today or at future time. So we're going to start at the beginning as a good place to start. So imagine this proposition. Think about that your life has ended and you're looking down from your cloud at those below, your loved ones below. Hopefully you're looking from up top versus any other alternative locations you might be at that time. So everything you're looking at tells you that your estate plan is working perfectly. What does that look like to you? What does that vision mean to you?
What do you think?
These are rhetorical.
No, really. What do you think?
Everything, your estate plan is working perfectly. Okay. Well, for me, that would mean that, and this is kind of a general question that we can already answer. We can get specific. That your heirs are taken care of.
Absolutely. Anything else? Do you have any thoughts?
Whatever you've saved over your lifetime went to them, and not toward other expenses.
There you go, like taxes, long-term care, that sort of thing.
Right.
Absolutely.
So you're looking at making sure the people you care about get your stuff, and at the lowest cost, presumably. Is that right?
Yes.
Yeah. No surprises? All right.
What don't you want to see? Other than unnecessary expenses.
Yeah. That something that could have been executed properly wasn't.
Right.
While you were alive. That something, your plan, you thought was well thought out, well put together, but
Right, exactly.
somebody missed something, and and hopefully not the professional you paid to help you put your plan together.
Well,
That is correct.
absolutely.
Welcome. Hi, good to see you.
Sorry, we're late.
That's all
No
right.
problem.
So all that being true,
Still on the first slide, so you're in good shape.
that's right, we're just on the first slide. So everything you said is true. So with that in mind, and we all agree that what we said makes sense, why then, in our experience, most estate plans not work effectively? And that sounds a little strange, perhaps, when we say, why don't most estate plans work?
Yeah, Rich, I have a will, and a lawyer did it for me.
Right. Yep.
Right. And here's the real problem. We think about the success or failure of a estate plan typically in the immediate aftermath of someone's death. Now, there are plenty of cases where we know right off the bat things are a problem, right? People are already fighting and doing all these other things. But sometimes we don't know whether our plan really succeeded or failed for years, months, years, or decades later. Because here's an example. Husband and wife, they own assets typically in what form of ownership?
Home.
No, how do they own it? Jointly. Jointly, right? Joint tends to right of survivorship. Because it's a natural assumption that you pass away, he's going to get it. Or actually, he's going to pass away first and you're going to get it. We always call it the husband first in our conversations.
Yeah.
Right. So, isn't that a fair assumption, right? But what could happen, if you have children, what could happen that something that she may or may not do that ends up the assets not going to the kids? What kind of things can happen to her? And this goes to any married couple, not picking on you personally.
Wait, you're talking about the surviving?
Yes.
What could the surviving spouse do, or what could happen to them that might screw the plan up a little bit?
We die at the same time.
Perhaps.
True.
But let's say you do outlive
Marriage?
a remarriage case, right? Someone remarriage. You're on your cloud. That's what we just had that proposition. You're looking down from your cloud at what she's doing. And she remarries. You're saying, don't do that, right? But she does it anyway. She can't really hear you at this point.
Yeah.
She says, don't do that. But she does. And what happens then? What happens if she dies first? Perhaps. Where the assets go? No, he's gone already.
The new husband.
The new husband might get them.
Yeah.
Even if she has a will that says everything goes to the kids, your husband can exercise what's known as a spousal right of election and take a third of the property. All right? Let's say, though, there's never remarriage, not an issue. What happens you get older? What happens to older people sometimes? They wind up in a nursing home, is the comment, right?
Or any kind of
So
long-term
this could
care.
be 10, 20, 30 years even after the husband's death. The wife then needs long-term care.
Yeah.
If proper planning wasn't done, then we have a scenario where the assets are not protected and may not get to your ultimate heirs.
Does anybody know here how
Why
much?
wouldn't they be protected?
Do you know how much a nursing home costs per month in Orange
Okay,
County, roughly?
So that's it, right, okay.
Yeah.
So you say why? The question was why wouldn't they be protected? Well, the answer is, remember, we had everything joint ownership. After the first spouse's death, nothing legally had to be done at that time. Everything passed to the surviving spouse. Sounds on the surface like a perfect plan.
Right.
But
Yeah.
we see the end result of things that don't occur, that don't end up in the way we want them to go. And the result was unintended because the consequences were not articulated at the time the people were doing whatever planning they did.
Yeah, so it's really, the theme here is really trying to anticipate, not necessarily they have a crystal ball, but planning far ahead.
Knowing
Possible.
Any scenario.
as many scenarios as we possibly can think about and as many options as you have. Right.
But it could be endless. Could you just go back to your example okay, so the husband passes away, the wife survives, the will is intact, she remarries, but nothing is redone with the will. So why is the second spouse entitled to this right of election?
Under New York law, they say that
Whether
any
their name
spouse,
is
under New York
in the
law,
or not,
they
or
say
the will
that
or not.
a spouse is entitled to a third of your estate, roughly. Yeah.
Okay,
In all
whether
states.
they don't have to be named in the will.
Not
Correct.
at all.
Just
In fact, it can
in
say,
virtue of being married.
it can say in the will specifically, I leave nothing to my husband, Shecky Green. Nothing goes there. However, by law, Shecky can come to a lawyer and say, I want my third. Or Mr. Lawyer, can you tell me, am I entitled to anything under my wife's estate, even though she says in her will I get nothing?
Right.
The lawyer, if they know what they're doing, will say, oh, yes, you can take your elective share.
Right.
And every state has that.
Shouldn't, as a reputable attorney, or that woman herself, if she remarries, shouldn't
She should absolutely
imagine
update her
to
planning,
redo
but we can't go and force her to
will?
do that. Right.
Right, but she would be well advised to do that.
Of course.
Okay.
Right, or do a prenuptial agreement.
But do we want to wait for her to maybe do that, or do we want to
Or
make
wait
sure
for
we're thinking
something
about
to
it now?
happen to her, which is what you postulated.
Right. And we'll talk about other examples of things that maybe aren't thought about in advance that become unintended consequences regarding your kids and things particularly. So we'll move ahead up from here. So we have a few smoke screens that sort of obscure effective estate planning in too many circumstances. The first one is the common will versus trust. We get calls all the time, oh, I need a will or I need a trust. That would be like us saying to someone coming to do work in our building, you know, I need you to use a particular kind of tool that you have. Because these are just tools of our trade. Wills, trusts, powers of attorney are just tools of our trade. You know, coming to you, I need you to use a certain kind of metal for doing installation of an HVAC system. Sounds silly on the surface, but that's no different than telling us what instrument you need to use. The real question is having a conversation, oh, our building is too hot, can you cool it off for us, right?
Yeah.
And you using your professional knowledge and expertise to accomplish that for us. Same thing here. You have to tell us, you generically as the client, what your concerns are, what your family structure constitutes, who are the key players in your world, what kind of assets you have, you know, how they're owned, and then we use our knowledge and expertise to advise you about the options you have for doing planning.
Yeah. Everybody calls up saying they want a will or they want a trust. Nobody actually wants a will or wants a trust. They want something to happen. They want they want that to get them somewhere. We need them to tell us where they want to go, and we can get them there with whatever document or documents is going to make sense.
You know, again, this may be one of those questions where we're going to get to it or whatever, but I was, historically, how have you seen the effect, say, in these phone calls that you get, of being able to literally log onto the internet and research so much? Do you find that people are maybe doing that and reading things and maybe are getting confused or don't really understand?
There's this great thing I saw online the other day, which said, "Don't confuse your Google search with my law degree." And I would add to that experience doing this for, with Rich, 15 years, with me, 8 years. Right, you can look, I can get a ton of information online on quantum physics. That doesn't make me a scientist. And I do
have
like
you seen that,
but,
the effects of that in the calls?
Oh, sure. Look, we've seen the effects of DIY estate planning all the time, and you know what? They're unfortunate. The kinds of money that's lost when someone knows or thinks they know what they're doing or trying to, let's be honest, what they're trying to do is not spend money on a lawyer. Okay? We know that. We're not dumb. But then they end up spending more money on taxes, spending a heck of a lot of money on a nursing home, having litigation arise because they meant to do one thing, but it didn't really work, and their kid says, well, this is what they meant to do, but it didn't really happen, so the other, all those things, but at the end of the day, look, I'm not going to,
Yeah, but and that being said, we certainly wouldn't discourage people from getting educated. This is the purpose of having a workshop that we do every month. We'd rather have people come and hear this and read the articles and even read stuff online and so on, and yet and then come in with a little bit more information. But don't assume you're ever going to learn as much as we do, or else we're in the wrong business and you should be doing what we do.
And that does happen on a regular basis. Clients will come in and say, hey, I saw this article, or I saw this, and we'll talk about it. We'll say, oh, okay, here's what that means, and here's how that plays in for you, or that doesn't apply to you, or whatever.
Right. The second smoke screen is the avoid probate, save taxes conundrum. People have this ingrained concern about the probate process. First of all, a lot of people don't even know what probate is. Probate is simply the legal process by which a person's individually owned assets must be passed and administered through the court system, because obviously, not obviously I shouldn't say that because a lot of people don't think it's obvious. If I own an account at a bank in my name alone, the fact that I'm married doesn't matter. My wife wouldn't have any legal control or access to that account after my death. If it was a joint owned account, that would be different, but that has its own set of pitfalls that we've already touched upon. However, so who can gain access and how can they do it to my bank account? Someone is going to end up with it ultimately, the money in that account. That's where the probate process kicks in. Someone has to apply for letters of either administration or letters testamentary at the time after my death. If I have a will, they can bring the will to the probate court, the surrogates court here in Goshen, and file that. And if there aren't any complications, the letters of administration can be handled very simply. But a lot of people, for understandable reasons, don't want to go through that process. It is a court process. There are filing fees, and they're afraid they're going to have to pay a lot in legal fees, which may or may not be the case. So they do a lot of things to avoid probate, which sort of ends up cutting your nose to spite your face in many circumstances. So, for example, go ahead. Yeah.
When we talk about wills versus trusts, certainly avoiding probate, saving taxes. Look, in most of our planning, do we seek to avoid probate? Yes. In most of our planning, are we looking to avoid taxes? Of course. But it's a many-faceted question, and we all have to keep everything in mind, rather than the only thing I'm worried about is avoiding probate. Because if that's the only thing you're worried about, you might, like Rich said, cut your nose off to spite your face. You might have avoided probate, but then you might be spending hundreds of thousands of dollars on a nursing home or something like that.
Or Shecky Green gets the money instead of your kids.
Right.
Yeah. You can't be mono. You can't just have blinders on.
Right. So the way we explain, as you're, I'm sure, getting a sense for, we have a fairly distinctive way of wanting to approach these things. And the best way to explain it, I think, is to first explain what I call the old way, or the, maybe the traditional way, but not traditional in a good way, like the outdated way. And we sort of touched upon this already. Like a client would tell the lawyer what tools to use, like I need a will. Instead of calling and saying, this is what I'm concerned about, how do I get there? A general practitioner, now disclaimer about general practitioners, look, Rich's dad was a general practitioner, my grandfather was a general practitioner, we do work with a lot of attorneys that are general practitioners. They're often very trustworthy, you know, great friends of the family or
Pillars of the community.
Pillars of the community, you know, like great people. The issue is that in this area, if you're doing a real estate closing in the morning, then doing a DUI in the afternoon, then the next day you're doing something else, doing someone's will, if you're spreading yourself too thin, essentially, and there's too much specialization in this area. So, you know, I've seen this unfortunately, and it used to happen a lot more, but it still happens quite a bit today. In fact, it happened in my own family. A general practitioner will prepare a will. And when I put prepare in those scare quotes, the idea is they're just plugging names into a computer. Now, here's a big secret. We have computers too, right? And we don't start from scratch every time either. We don't plug names into documents. It's a little more sophisticated than that. But at the end of the day, this attorney in this case, they're not really having a long, detailed, informed conversation with their client about what the client's options are, what the client's goals are. Part of our job is to be a little bit Socratic with you. You might tell me your goal is one thing, and I try to help you flesh that out because I know how these things can play out because I deal with it every day. But that doesn't really happen here. It's kind of the second point here, or the third point.
Right, so you'll see here, you won't get that question. Well, what happens if, you know, your wife remarries or needs a nursing home? They're not thinking, you know, 6 steps ahead. That's really the biggest deficiency that we see in sort of the general practitioner mode.
Right. And at the end of the day, you know, they're charging their client for what essentially boils down to word processing, which isn't a lot of money, but there's almost zero value there anyway. And the fourth bullet here, there have been trusted estate specialist attorneys for decades now, but they really were more tax focused. People would focus in the area of trusted estates because of the estate taxes and certain things like that. And a lot of times if an attorney had that level of education or expertise, they might be trying to recommend fancier kind of tools where a client wouldn't necessarily really need that. I had a woman come into a workshop like this once, and during the break, she mentioned, oh, you know, it was a CPA in this case. She said, my CPA, my accountant recommended something called a QPER, a Qualified Personal Residency Trust. Now, that's the kind of thing you might want to be looking at if your estate, if you're an individual, is about over $5 million, or if you're married, your estate, combined estates are over about $11 million. We'll get into the specific numbers in a little bit. So I said to this woman, oh, okay, so this is your rough, you know, estate worth? And she laughed at me. She said, no, I don't nearly have that much. You know, she had maybe like $800,000, something like that. And I said, then I'm not going to bother you. I'm not going to waste your time with a QPER. Have I done them? Do I do them? Yes. But, you know, I'm not going to try to regale you with what I know about QPERs if it just doesn't apply to you. Why would we bother talking about it? So while people have specialized in this area, oftentimes they can miss the forest for the trees. They get too bogged down with technical parts of planning without keeping real world, real person stuff in mind. Okay.
So let's talk a little bit about the philosophy of an estate plan from a definitional and a standpoint. So here's how we approach it. First of all, the first fundamental precept is I want to control my property while I'm alive and well. Everyone wants to control it. There are different ways to control it in a way that can be protective for you, for your kids, your spouses, and so on. And we're going to talk more about that in general. But everyone, I think, starts from that idea, I want to control my property.
I think, and the reason we spell it out, too, is that I think people sort of take that for granted. I mean, while we're alive and well, of course we want to control it. But when you're doing protective planning and things like that, we don't want to lose sight of that. We want to do planning in such a way where you're maintaining as much control as possible.
Right. The second point is I want to plan for me and my loved ones in case I become disabled. We think about estate planning all too often, unfortunately, only as death planning. But a lot of the planning results, good and bad, are derived by what happens and what mechanisms are in place to deal with incapacity or disability. So we're going to spend some time on that too.
One of the things I've started saying quite a bit is the question used to be, the reason people say I need a will is because the question always used to be, what's going to happen to my stuff when I die? The question is shifting now because of rising long-term care costs, because a nursing home could cost $12,000, $13,000 a month. There's one in Riverdale that's $28,000 a month. The question isn't what's going to happen to my stuff when I die. The question is, am I going to have anything when I die?
And the other thing is with longevity, we're living longer, but not necessarily better. You know, 40 years ago, life expectancy was probably under 70 years of age. Now people are living, you know, dozens and dozens of people a day are living past 100.
I got a client turning 105 in a couple months, I think it is.
Yeah.
Or maybe this month.
So we have to shift our focus and continually so into how we deal with incapacity. The third bullet point, or third point, is I want to give what I want, when I want, to whom I want, the way I want. What I have, what I want typically is what I have, my stuff, my assets. When I want, well, most people are thinking about after death, but you certainly can do lifetime gifts, and we'll spend a few moments talking about gifting.
Or transfers not when you die, but years after that. Depending.
That's true.
Again, it's all
To whom I want, that could be spouse, could be children, could be other family members, could be friends, could be charities, or all the
season of giving. Could be
all the
charity.
above, exactly. And the way I want. Now, this is the one that sort of is a fundamental difference from the way we approach it, or the discussion, than what I think the average planning scenario takes place, because most people assume they're just going to give to their kids. We're thinking about outright distributions. My kids, as long as they're not children, whether they're 21 or 51 or 81, they're just going to get their stuff. And on the surface, that's an appealing thing, and certainly from the children's perspective, they think that sounds pretty good. Oh, I want to get my stuff. But there's a lot of risks with taking an outright distribution where we can have protections. And what are some of the risks that we're talking about? What happens to adult children that is not always a good thing? What kind of legal process that they may engage in?
It can happen to married adult children.
They
There
get
you go.
divorced, yes. We know the statistics, and it's quite frequent. So if people inherit property and it's in their own name, what do they, and they're married, where does the money usually go? What kind of an account? We talked about that earlier. Joint account. So what happens to that inherited money that was now in a joint account and the children get divorced? Guess who gets half of it?
Is that subject to that third joint, that 1/3?
This is different.
Spousal right of election?
No, because that's only if they survive as a married
Only if
spouse.
they survive,
Here we're
okay.
talking even worse, because most cases you're going to have a fairly equal split of the assets.
Yeah, no, but suppose that adult child who was gifted or left marries, and that person passes away.
Yes, I mean that's
Right.
partly true. Also, if they want to, the other thing is in talking about not a non-outright distribution. What we're talking about is leaving it in a form of a trust for the adult child, because you can specify, well, as long as my son or daughter is married, that they can use and access the trust property as much as they want. But if they die before our daughter-in-law, we don't have anything against her. Maybe we do, but we don't. We want to make sure it goes to the grandkids. And in an outright distribution, that will not be guaranteed. So these are all the scenarios that really talk about. So we're going to spend more time talking about the way we want to leave assets. The form of inheritance is very important to get it right. And the last piece is we want to make sure we're doing our planning at fully disclosed and controlled costs to not only me, but those I love. Because a lot of the costs of estate planning aren't traditionally known while you're alive. That's what happens when you die. The kids will go see the lawyer, and the lawyer says it's going to be X dollars or X dollars per hour, or a flat percentage of the estate value. All these things are done in terms of the cost of administering an estate. And unfortunately, all too often, no one knows what the assets consist of, so we have to go through all kinds of forensic exercises to go find the bank accounts, and that increases the cost, increases the delay. What we'd rather do is know what we're going to pay right up front, not only during our lifetime, to maintain our plan, and to settle the estate when we die.
So you're saying you can actually know ahead of time, you can control it?
Yes.
That way you can know ahead of time?
Yes,
With our process, you can.
that's right. So that's all important.
All right.
So we're going to spend a few minutes. I mean, taxes, when I first started doing workshops, which goes back almost 16 years now, is 1999. It's almost 17 years, actually, right? Taxes and estate taxes was enemy number one. Back in those days, as ancient as it was now, the estate tax exemption in New York, when I started, was $600,000 per person. We are now at a much higher level. So, but notwithstanding that estate taxes applies to relatively few people, it's important you understand it so then we can shift back to our focus on more of the personal planning goals that really affects everybody.
Yeah, even though I could sit here and tell you, look, taxes just aren't that big of a deal anymore when it comes to estate taxes, chances are you're probably going to want to know what I mean when I say that, which is why we go through this. Because taxes, of course, are a concern that a lot of people have.
So what's the real story with estate and gift tax?
Here's the real story.
So let's hear about gift taxes first.
Yeah. Where we start with this is that the government taxes us on the privilege of transferring assets, giving them to somebody else. It's a tax on the privilege of the transfer. It's not a tax on the money itself. Technically, legally, a tax on the money itself would be unconstitutional, which is why the government slick lawyers say that it's a tax on the privilege of the transfer. Back in 1916, when they first passed the estate tax laws, that was the answer, basically, when there were constitutional challenges. So how do we see this? So during lifetime, it's not estate, but it's the gift tax that we could potentially run into. Probably not, but it's there. So first off, why don't we see this every day? When we give a nice gift to somebody or make any kind of other transfer, you're allowed to give up to $14,000 per person per year without it even showing up on the government's radar. It literally is not considered a gift in the IRS's language. So I might give Megan $14,000 and she would say, "Thank you, Austin, for that nice gift." And I'd say, "You're welcome," because I know what she means because I'm a real person. But let's say Rich is with the IRS, he'd look at that and say, "Wait a minute, I didn't even see a gift." Because in the language of the IRS, anything that's $14,000 or under per person per year is just not even considered a gift.
Oh.
Big, and we mentioned this a little bit later, but when I'm thinking of it now because it's that important. Yes, sir.
What about the person who gets the gift?
Great question. It is not income to that person.
It's not.
They don't pay. They are not. There's no such tax. Gifts and
No.
No.
Yeah, it's not income.
Right.
Okay.
Gifts and inheritance, received gifts and received inheritances are specifically excluded from the definition of income under IRC, I think, section 61.
And most people are, I think, contrary because we're so used to virtually everything we receive being taxed.
Right.
That's one of the exceptions.
Yeah.
One of the few.
That's a great question. All right.
We ready to move on?
Yeah.
Okay.
But so you're saying, oh, so I should really not give away more than $14,000 per person per year? Well, hold on, because every person, you have a lifetime exemption amount of $5.43 million. It's actually going to be $5.45 million as of January 1st. That means above and beyond $14,000 per person per year, to anybody, by the way. It could be the hobo on the side of the street. They don't have to be related to. You can give over $5 million worth of gifts, and the IRS sees it as a gift. They say, oh, hey, you made a gift. And you say, you're right, I did, but guess what? I've got an exemption, so I don't have to pay tax on that gift. And they say, you're right, no tax owed. Have a nice day. This is only for federal law. New York State does not have a gift tax. Big, and when we redo this, I'm going to bold this out. This is only a tax rule. This is only a law regarding taxes. It is not a Medicaid rule. So you can't, it's not a good idea to try to get rid of all your stuff, at least without having talked to somebody about it first, for Medicaid purposes by giving $14,000 to each of your kids each year, or $10,000 to each of your kids each year. I've heard that a lot. Somebody will say, oh, well, I'm giving each of my kids $10,000 a year, so the nursing homes don't get it. And I say, well, guess what? If that's within the 5 years of you applying for nursing home Medicaid, they're still going to get it. This is a tax law alone. And I see a lot of accountants will recommend doing this to try to protect assets, and it's not a thing.
Question, I think.
Oh,
Yeah, you're saying that the gift tax wouldn't apply for a nursing home? If you give a certain amount of money away?
What I'm saying
I
is,
understand what you said.
yeah.
If you try to give all your money away, that brings a red flag.
That's
for
correct.
Medicaid, yeah.
For Medicaid,
exactly,
it will.
Yep.
So even though you did it, say $14,000 per beneficiary. Let's say you have 3 children. You each gave them $14,000. That's a fair amount of money you're passing every year. That's not subject to gift tax. But if you did that over 3 years, and that's say $120,000 you've given away total, and you need a nursing home within the next 5 years, that's going to come back to bite you in the rear end.
So what would be the recourse there? What would be done? The money's already given away.
We're going to cover that after the
Yeah.
break. We're going to talk about the Medicaid rules and gifting and how that affects that.
Best-
How about the state tax on a gift, the federal? There's no charge for that, but what about the state?
Look at
New
that.
York State,
Next
no
slide.
Huh?
No gift tax in New York State.
Oh, no
There you
gift.
go.
Say.
Good question. We're a slide away from
No
it.
gift tax, but the gift that you gave for the federal, does that come back into the state somehow?
Only temporarily till 2019 would a lifetime gift affect your estate tax liability under New York law if you die before January of 2019. So the real answer is very minimal impact on gifts under New York state law.
Yeah. Probably
Any
not.
gifts of any amount?
Any amount.
Right.
So not subject to that.
Not,
14,000.
there's no, yeah. Now again, the Medicaid rule is a whole different rule, and that is
Yeah.
very much a New York State enforced rule, even though it's under federal law too.
Unless you are absolute, honest to God, intent in giving the gift is to have that, see that person enjoy it during their lifetime, there is virtually no reason to do really large lifetime gifts directly to whatever beneficiary we're talking about. If you're trying to accomplish some sort of asset protection goal, then there are better ways to do it. We're going to talk about it.
Yep. Now, as far as the numbers go, as Austin mentioned, while we're at a 5.43 million exemption come January, a month from now, we're going to be at 5.5 million. So they're going up 5,450,000.
Right.
It's only increasing by $20,000 next year.
Not a lot
It's
this
tied
year.
to inflation. The gift tax rate, which started, for years it was $10,000 per person, and it's been subject to inflation increases for a number of years. Essentially what happens is the government increases it only in $1,000 increments, and we haven't quite hit that inflation level yet to bring us up to $15,000. So in 2016, once again, we will have a $14,000 annual gift exemption under federal law. The tax rate for amounts over the 5.43 million for those relatively few people who have large enough estates would be 40%. So it's a big rate, even though the exemption is quite large.
Does anybody have a guess how many estates actually have to pay federal, had to pay federal estate tax? I'm using 2013 numbers, but do you have any guess? What percentage? What percentage of people that died in 2013?
30%.
Much lower.
Yeah.
Yeah. So we're talking about basically how many people, what percentage of people who died in 2013 had more
Over
than
$5
$5
million
million
estates.
roughly?
Yeah.
You have any
In
guess?
New York State, you're asking
No,
New York
across
State or
the
federal?
country.
Across the country. What percentage? 30% was way too high.
Less than 30 in the whole country?
Lower. Lower than 10%. Lower than 5.
Oh, come on.
Keep going.
How did they do that? 2?
3.
Lower than 3.
2.
Lower than 2.
1.5.
I'll get you.
1.8.
1/3%.
Wow.
1/3% of Americans actually had taxable estates for federal
Well,
level.
think about it. How many
did
people
they
have
do?
over $5 million? Not that many.
Well, they figured it out.
We've
Yeah.
had, we,
Well, 'cause they had to
we
file a
numbers
tax
reports
return, so-
About the melting away the middle class, we're getting
Right.
the wealthy and poor people.
Oh, you're right. The whole
falling
income,
into working poor.
right? The inequality issue is true, but we still, even though the people at the top have a huge amount of the wealth,
do.
they're really few in numbers, frankly, and that's why only
There's not a lot of
0.3% in 2013 had federal income tax, estate tax implications, frankly.
And
Trump won't fall at 100%.
Yeah. So that's why we said earlier that the estate tax exemption amounts having increases they have has really taken estate taxes out of the hands or out of the impact of a significant number of our population. Now the ones who it affects are, a lot of people own businesses that may be worth multiple $1 million, and certainly people have a fair amount of wealth to begin with. New York for years had only $1 million per person exemption, and that was in effect until last year. And that created a problem. As our federal exemption was increasing, the state estate tax exemption stayed $1 million. So for that relatively few percent of our population that had federal estate tax obligations or implications, many more people are being subject to New York State estate tax. While there are relatively few people who have $5 million estates, there are quite a few people that have $2 million estates, right? And so we had many people paying New York State estate tax. So finally, in light or in response to the concern that wealthier New Yorkers were abandoning the state, not only because of high income tax rates and other taxes, but primarily because of estate tax issues, they're going to Florida, for example, or the Carolinas that don't have a separate estate tax. In April of 2014, just a little less than 2 years ago now, the New York State legislature and passed into law and the government signed into law an increase in the New York State estate tax. So we see that in today's numbers, or actually through March of this year, the estate tax exemption was just over $2 million per person. Beginning April 1st of this year, it went all the way up to $3.125 million. Next year, next April, so it's only about 4 months away now, we're going to shoot up to $4.1875 million. A year after that, we're going up to $5.25 exemption. And then on January 1st, 2019, it's on the slide, well, actually it is, subsequent years, New York State estate tax exemption will be indexed to inflation to match the federal exemption. So if in 2019 the federal exemption is $5.75 million per person, the New York State estate tax exemption will be the identical amount.
So, I'm sorry, by 2019?
January 1st, 2019 is when we have the reunification of the federal and state estate tax.
As long as you live until 2019, you have to have over $5 million to have any kind of estate tax implications, or you know, probably 11, 12 million if you're married.
Married couple. So while we've had this sort of dealing with the New York State estate tax as a separate concern for a long time, it's certainly becoming less and less of a concern. Now, a few states, New Jersey, Pennsylvania, still have lower threshold amounts. So for people residing in those states, we do have that same concern. But New Yorkers, thankfully, again, except for the very super wealthy, it's not a big issue. Yes, sir?
Is real estate counted in your,
Oh, yeah.
in other words, not only cash and bank accounts and stocks?
Yeah.
Anything of value.
But if you own a couple of buildings, the same thing, that's all added up.
Same
Yeah.
thing if you own a business. You don't know what it's worth, so you got to get a, you know, after your death, they have an appraiser that has to be hired by the estate to appraise the value of your business, and that will get put into value. Your IRAs and 401ks, that's part of your estate. Life insurance that you own, or have what is known as an incident of ownership, typically ownership, will count in your estate. You could have a term insurance policy for $2 million. Doesn't do you any good during your lifetime. And if you have, say, $4 million of other assets, you die owning that $2 million term life insurance policy, voila, you have a $6 million estate. You've gone from a non-taxable estate to a taxable estate just by virtue of having that $2 million term life insurance policy.
That's another little legal dance move that the government did. So for pretty much every other kind of asset, the way they value it is what it was worth the instant before you die. For life insurance, for term life insurance, what it's worth the instant before you die is nothing, because there's no cash value. For cash value life insurance, what it's worth the instant before you die is the cash value. But the government said, oh, well, we're going to make it the face value. Just forget we said that about it, you know, everything else.
That's right.
It's
Face value of both?
of any life
Cash value
insurance,
and
yep.
return?
Yep.
Really? At the moment of death, at death?
Just
Yeah.
whatever the face
The value
value,
is.
whatever the death
Regardless
benefit,
of the
life
cash
insurance is.
value?
Regardless of cash value.
Right.
Yep. Just a brief history. The estate tax exemption, it's increased again starting in 2000. It went from $1 million to $2 million, and then it stayed that way till 2009 when it went to $3.5 million. 2010, the year George Steinbrenner died, he had 1 year of no exemption, or no estate tax federally, so he was able to pass his estate without being subject to estate tax.
George Steinbrenner had the best estate tax plan of all, which was to die in 2010.
Right. Then it was reinstituted because without further congressional action, this unlimited amount was going to go back to the $1 million limit that we saw in 2000. That was called the sunset law, sunset provision, I should say. So Congress did not want that to occur, so they compromised with the president, one of the few things there's been compromise of in the last 8 years, I think, to institute a then $5 million exemption with inflation built in. And that's where we are today at the 5.43 exemption. There's no more sunset law. This law will remain in effect forever unless Congress acts again, which they certainly can, but there is no automatic repeal of the law as there would have been in 2010. So we have a concept of portability, which was enacted under the theory by Congress years ago. This is going back in 2010 when the first compromise law went into effect. Historically, the only way each spouse could take advantage of those exemption amounts, whether it was $1 million or $2 million, whatever is in effect at the time of death, was that the first to die's spouse's assets had to be parked into a trust, what we call a credit shelter trust, or in our practice we call a family trust.
Millionaires had to do basic trust planning.
Right.
Yeah.
If instead the assets passed by survivorship or other operational law to a surviving spouse, or even under a will or trust that said it goes directly to my surviving spouse, the exemption amount of the first spouse to die disappeared. So Congress didn't think that was fair. There was complaints apparently out there. I don't know who, but people were complaining. And so they passed a law that said spouses, you can now, the surviving spouse, can utilize the exemption amount of the first to die, even if the surviving spouse receives that asset directly to him or her. And that's what the concept of portability is. So portability on its face has some value, and it's certainly the default for people who haven't done any planning, even wealthy people. Yeah, they can use portability, but it's not really a strategy to rely upon for a number of reasons. One is New York State hasn't adopted, and most states who have a separate estate tax haven't adopted portability, and therefore, even though you could avoid a federal estate tax by just passing assets directly to a surviving spouse, failing to park the assets in some form of trust can cause significant state estate tax liability. On the high end, we're almost talking $300,000 in New York. The other thing is by passing assets into a trust for the benefit of a spouse, rather than having the assets go directly to the surviving spouse, it allows us to do some more competent and complete income tax planning. We're going to talk about it in a minute. I'll let Austin cover that piece on capital gains taxes and how our shift has really gone from estate tax planning, because it affects so few people today, to more of the income tax planning benefits of doing good estate planning. So why don't we shift into that piece on capital gains taxes?
So as we've sort of laid out, because of how much money you're able to pass to the next generation or to a non-spousal beneficiary, being millions of dollars, estate tax planning is just not relevant for literally 99.7% of people, right? What is relevant to a lot of people, especially when we talk about people wanting to avoid, long-term care costs, so they're giving assets away without talking to us first, is the capital gains tax. Capital gains tax can affect you quite a bit, and here's why. So just so we're all on the same page, what capital gains tax is let's say I buy, it goes for anything that increases in value. So real estate, stock, something like that. Just for simplicity, I'm going to talk about stock. So let's say I buy some stock at $5 a share. And I hung on to it for a while, and it increases to $15 a share. That $10 increase, that's capital gains income. And when I sell the stock, I got to report that as income and pay the tax on it, which is like 28% now. It's a lot. Second scenario, so I buy this stock at $5 a share, and it increases to $15 a share. Then let's say I give it to Rich. I don't have to pay tax at that point, but when Rich sells it, he'll have to pay the tax on that capital gains that's in that stock.
Let's assume a third. That's like $5 or $3 in tax on a $10 gain.
Exactly.
Almost.
It's going to be real, especially when we're talking about $200,000. We're talking about a house or something. Third scenario, and here's where you're going to see where the rubber really meets the road. I buy it at $5 a share. It increases to $15. Then, because of my death, it goes to Rich. Rich turns around and sells it. How much tax does he pay?
On everything he sold, nothing?
Zip.
Wow.
What happens is that's why they call it a step up in basis. When I buy something for $5, that's my basis, that $5. And then the tax is whatever it's worth now minus the basis. Upon my death, that basis goes from 5 to whatever the value is upon my death. It's stepped up. So when Rich turns around and sells it, it's 15 minus 15, 0 taxable income.
So that's the wipe out of the tax, right?
It just, you don't have to pay. And so, and you can see where this would matter. So say, and this happens, I probably say on a monthly basis now, honestly. I get a phone call where, well, I'm concerned about a nursing home getting my house. I say, fair enough. I mean, that's part of what I help with. I want to give it to my kids. Slow down. You bought your house in 1965 for $15,000. It's worth, just for math's sake, let's say $215,000 now. Now, you have a capital gains exemption on your primary residence, so whatever. But let's say you give it to your kids. They're not living there. When they sell it, they're going to have to pay a third of the increase in value. So a third of $200,000, they're going to have to pay that in taxes. That's a lot of money. And yeah, you might have saved, and that might not be, like say the whole house then didn't go to long-term care. Well, you've won a little bit. But if we could do it in such a way where it's protected against long-term care, and you get this step up in basis where they're not paying that extra tax, that's the way you're going to want to do it.
How do you do that?
We'll talk about it in a minute.
So a lesson about taxes is that an experienced and knowledgeable attorney will tell you about whether you need tax planning, but a counseling-oriented attorney will spend time to learn about you and your family so that the tax tail doesn't wag the dog, such that we don't overlook the personal planning issues about who you really want to get your stuff and how you want them to get it. Because we can solve tax issues and end up still with a terrible result where the new husband ends up with the property or your son's former wife ends up with the property. And we don't want that to happen. We want to solve the tax issues, but also make sure the personal planning objectives are met as well.
Right. We end with that for a very specific, or not end, but we end that segment with that for a very specific reason. We spent a while now kind of nerding out on taxes, right? But at the end of the day, it's the personal goals that are going to drive the planning. We're just going to do that in a way where you're not paying more taxes than you have to.
Right. And that really fundamentally, or points out a fundamental truth in our opinion. There's a distinction between word processing, that is the vast amount of planning that is done in this country, versus counseling-oriented planning, where there is a give and take and asking a lot of questions rather than us just being scriveners, writing down what the client says, cranking out a will that does exactly that without any professional assistance or advice about the implications of if you do A, B, and C. And that's a huge difference. So we can have the world's greatest documents, we generically as attorneys or us in particular, but if your assets do not match, the ownership of your assets does not match the planning that you have in place, the planning isn't going to work either. We're still not going to meet our perfect picture from our cloud story. So the magic rule is that the title of your assets will ultimately equal the result and who gets those assets.
The thing I like to say about it is doing the documents does not act like a magic wand. And it doesn't automatically apply to everything you have. You have to make sure, like we're going to explain to you, that they're titled in such a way where it is going to either pass through your will, if that's what we're trying to do, or pass through your trust, if that's what we've done.
Right. So there are 3 ways you can own property, 3 fundamental ways. Let's think about, or let's look at the 3 ways that you can own your property at the time of your death and what the result is at each of those cases. First one is if you own assets in your own name at death and it doesn't have a in trust for or pay on death designation, which is something that can be done, those assets will end up going through the probate process. And that will be the case whether you have a will or if you don't have a will. Some people think, oh, you only go through probate if you have a will. That's not true. If I own an account in my name and I don't have a will, there's still no one with legal authority to administer that and distribute it to whoever is supposed to get it when I die. The only difference is if I have a will, I've designated a person who's going to handle that, known as the executor or personal representative. And it says in the will who gets it, right? If I don't have a will, I do, though. The state of New York's written my will. If you're just to sort of see if people have any thoughts on this, if you are married with children and you die with property in your own name, how is it passed under state law if you have no will? Any ideas on that?
If you have no will.
If you have no will and you have property, what goes to your spouse, what goes to your kids, or if anything?
Well, isn't it that 1/3 rule? For the
That's a little
death?
different.
You've passed away already.
If you die without a will, it's called intestate.
Right.
If you die with a will, it's testate. So you're intestate without a will. Under state law, your spouse will get the first $50,000 plus half of whatever's left, and your kids will get the other half, which is probably not what most people would choose at that time.
If you wanted your spouse to get everything and then your kids get it, that's not what the state has done for you.
Right. And if you have a minor child or disabled, it adds further complications. But anyway, the biggest complaints about the probate process, which is again necessitated by individually owned assets, is that first of all, it takes some time to obtain what are called letters testamentary or letters of administration, depending on whether you have a will or not. But so in simple estates, we get them in a few weeks. But if there's an issue of a missing heir, or there's some contention among the heirs and someone won't sign off on the appointment of the designated executor or administrator, in that case, it could take months to get letters, and that could be very frustrating. There are costs involved. In New York State, if you have a more than a $500,000 probate estate, I believe it's a $1,000 filing fee to the state, to the county. And there are, of course, going to be attorney's fees regardless to do that. But in most cases in a probate, there's no prearranged scenario between the deceased person who was the client and the attorney who's administering the estate. So it's left up to the heirs to have to work out whatever deal. They're grieving. They're really not thinking about the cost as much. So attorney can pretty much say whatever they want to charge, and the kids are likely going to pay it. And ultimately, the last thing is it is a public record. Everything in your financial history can be divulged as part of the probate process. The records are down in each county we have here in Goshen, the surrogates court down the road here. And if you have some time to kill or want to see something interesting and go, you can look up any file for anyone who's ever died in Orange County and look through their records. And you can sit in the courtroom when they're doing the calendar call, and you can hear lots of fighting and arguing. It's similar to like a divorce, often though involving siblings and things like that. So
Lifetime of pent-up resentment instead of just 20 years.
Correct.
Yeah.
Yes.
I started out doing estate litigation before doing just the planning, so
yeah.
I've seen it.
And the one thing we'll say on that vein is that, and we tell our clients this all the time. It's really important, again, part of the counseling process, to be honest with yourself, honest with us about the nature of your children and their relationships. It's important for us to know where these hurts are and where these little disagreements are, because that's only going to exacerbate after your death. Parents act as the glue. They can sort of typically hold things together. Not always. Sometimes the schisms occur while the parents are alive, but many times it really explodes after death, and it's important for us to know the likelihood of that so we can plan around that.
Mm-hmm.
So the second form of ownership is owning assets jointly at death. Those are when your assets, as we talked about at the outset, will pass automatically to the surviving owner. Sounds very appealing on its face. It's simple. It doesn't involve pesky lawyers. You can go to any bank or financial institution and they can set up a joint account for you. But there are a lot of negative implications, because the only one who really owns an asset in that way, it's not the two people who are standing there, or three. You can have multiple joint owners. It's the one who is living the longest. That's the only owner. And unless that person does exactly what you want them to do and don't get sick and don't get remarried, you have no protection for that. The other thing you have on some of the other dangers of joint ownership, we see this a lot where you have a surviving parent, a widow or widower, who ends up, usually at the suggestion, the well-intentioned suggestion of someone at a bank, to say, oh, Mrs. Jones, why don't you add your daughter Sarah on your account? She's always here helping you. The weather is going to get bad eventually, even though it's not right now in December, but someday we're going to get winter weather, right? We think. So why don't you let her handle all your banking for you? Now, forgetting for the moment that we can do powers of attorney to do the exact same thing without the negative consequence of joint-owned property, inevitably people add their kids on these joint accounts. The problem is Mrs. Jones, she did her will 20 years ago with the general practitioner down the road after the husband died. It says, I want everything 50% to go to Sarah and 50% to go to my daughter Joni down in Texas. So mom dies, and now she has 3/4 of her assets that are at this one bank are now jointly owned between herself and Sarah. So who owns it when mom dies? Sarah. Does the will matter in that case? Does it say when Joni comes to the lawyer, says, but it says 50-50? And our answer would have to be, it means 50-50 of what the probate assets are. But that's not fair. Maybe, maybe not, right? But certainly Mrs. Jones, the client, if you asked her during her lifetime, most likely her intent would have been, yes, I want my assets to pass 50-50. So when the bank lady tells her, put your daughter Sarah on the account, she doesn't understand how that's going to upset the apple cart. And that's one of the biggest failures that we see in doing that. And so many times we'll review wills and trusts, and we'll have a conversation. Did your lawyer ever talk to you about your assets? No, the lawyer has no idea that the assets, that the will says 50-50, and yet most of the assets are not even going to be governed by the terms of the will. We're already lost before we started. That's a big problem. The last type of ownership, and in our opinion the best, is contractual ownership. There are a number of types of contractual ownership which give you the ultimate control, going back to our definition of I want to control my property while I'm alive and well, and this gives you a way to control it even beyond that. What are familiar examples of contractual ownership, things that we have in all of our lives? Life insurance, you sign a life insurance contract, and that tells who gets the proceeds when you die. It doesn't have to pass through your probate estate. Annuities are likewise. A lot of people have annuities out there. Everyone who has retirement accounts these days, either IRAs or 401ks or 403bs, those are contractual instruments, and your designated beneficiaries will receive those accounts or assets after your death. So there's more control with contractual ownership. Just going back to this for a second, we don't have it here. You can have bank accounts or in stock accounts as contractual ownership. You can go to a bank, and instead of saying put it on Joni's name, you can say on the account, I leave it in trust for Joni and Sarah equally. And so upon death, it will, even if it's not passing as a probate asset, it will go equally to your daughters. And that's still, in our opinion, not usually the best way, because it doesn't provide protection if one of the girls gets divorced later or they need long-term care or otherwise. But it's still better than joint ownership, because you're not going to throw the whole planning out of whack in the way that we talked about. So the lesson of titling is really important as follows. Titling of the assets is critical to the success or failure of the estate plan, regardless of what legal documents you do or do not have. And it's not only important to consider ownership of assets, but the beneficiary designations on accounts, on assets that require beneficiaries, such as retirement accounts, annuities, and life insurance contracts, are critically important. And ultimately, your assets are not likely to stay the same over the course of your lifetime. You're going to get into different investments, get in different banks, and so on and so forth. So having a formal maintenance program to monitor the status of your ownership and the funding of your assets is really the best way to ensure the optimal result at the time of your disability or at your death. So hopefully you're seeing the confluence of multiple angles here. Proper kind of structure of legal documents matching the ownership of your assets. So we're going to cover a couple little stories here. We're almost approaching our break. In about 15 minutes, we'll take our break. The first story is what we call the bucket story, and this highlights the importance of proper titling of your assets. I can create a bucket. So pretend my little cup here is a bucket. It is a bucket in a way, it's just a very small bucket. Can't do a lot with it, but hold a cup of water. So if I need to do some cleanup around the yard, and my old bucket is worn out or rusted, or the dog chewed it up or whatever, if it was plastic, something like that. So I go to the local hardware store, or go to Goshen Hardware, and I'll buy a new bucket. I take it home, I put it on my shelf until I need it. But sitting on my shelf, does it really have any real utility or value sitting on that shelf? What do I have to do to the bucket to make it earn its keep, for lack of a better description? And how do I use it? How do I put it into use? You have to put something into it, correct? So we have to create our bucket, which in our example is our estate plan, right? That is the bucket we're referring to, the analogy. But it's not enough to just have the documents created. We have to fill the bucket up. So when we do an estate plan, we have to make sure that we retitle your assets, name the appropriate beneficiary so that everything flows into that bucket, which in this case is likely going to be a trust, or it could be a lifetime trust, we call a living trust. It could be a trust created under a will too. It doesn't have to be just a living trust. But we have to make sure that the bucket is filled either during lifetime or the beneficiary designation will force those assets into that bucket when we pass away. So that's important. The second story is the babysitter story. This story will highlight the importance of properly updating your estate plan on a regular basis. So I'm going to turn this over to Austin for a moment as an expert babysitter. We say that jokingly.
No, I'm 34 and I haven't changed a diaper yet, so one day it'll happen.
But he's good at telling the babysitter story, so I'll let him take over on that.
Okay. I do take my friends' kids to movies sometimes, if that counts for anything, but no real serious babysitting. Okay, so let's imagine young couple gets married, has their first kid. After a couple months, 3 months, whatever it is, 4 months, I don't know, because I don't have any kids that I know of yet, they are able to give the kid to some babysitter, whether it be a family member or a close friend or something, and able to go and try to have a nice meal, presumably fall asleep in their plates, something like that. What do they leave with the babysitter? And yeah, the baby, but what else do they leave with the babysitter? All right. So they leave like a list with information, right? Which has what? Phone numbers? What else does it have on it?
Location.
Yeah.
Where they're going to be, what time will be home.
Okay. Like when to feed the baby, what to feed the baby. In fact, did we put this on here?
Yeah, you have your list.
Is it? Okay, so.
We'll save that for afterwards.
Yeah, instructions.
Oh, yeah.
Well, we could put it up.
Yeah.
Right.
Slide to the next. This is my list.
I can't read it very well.
When, yeah, the scanning job wasn't great, but I took a picture of it with my phone. A couple years, I've been, telling this story for 5 years now. And a couple of years ago, on Mother's Day, my grandmother came to my parents' house and brought a scrapbook, and it had the list that my mother gave her when she left me with them, 33 years ago, or 34, 33 and a half years ago, whatever it was. And, waking up at 5:30, 6-ounce bottle.
His mother must have been a real detail-oriented person, I'll tell you.
She cared.
She had it down to a science.
Yeah.
That's what we said. This was her.
Yeah, exactly. I was her firstborn, she wasn't messing around.
Yeah.
Around 3:30 is my 6-ounce bottle of bourbon. I had a cigar at 4. Yeah. Sure. No. But, so I thought that was cool. I figured we'd put it in the presentation.
I like this. He went to bed at 6. Holy cow. Oh my gosh.
According to her, I was the greatest. I, went to bed early, stayed asleep. Yeah. I don't know what happened, but, I used to be good. My girlfriend wouldn't say that. Anyway. So we got the list. Fast forward 10 years. 10-year-olds, from what I understand, are not the age that you'd be leaving them home alone. So let's say the parents want to go out for dinner or something like that. They get a babysitter for their kid, right?
They should.
Does the list look at all the same as it did 10 years prior? No. What few things have changed?
You're probably not going to bed at 6 anymore.
Yeah, right.
You're not going to be changing the diaper.
Yeah.
Right.
Not going to be changing.
Yeah, so the kid has changed quite a bit. Maybe, the parents' lives have changed. They have different phone numbers or something like that. It's a different restaurant they're going to leave a phone number for the restaurant too. The babysitter presumably is different. Or maybe it's not, and maybe the only thing they're leaving with the babysitter is a brief update of the list. Oh, well, here's the restaurant's phone number, you already have ours, you already know how to handle a kid. A lot of different ways you could slice that. So let's rewind again back to when the kid is born. What's another kind of a list in a way, or set of instructions that parents get done after their first, or after they have children, usually?
List of instructions?
A more formal legal list.
Yeah. Ones that we might help them with.
Well,
Yeah.
We got it.
Well, with the guardian
Right.
being the primary focus.
And you kind of exactly, you're going into my next issue. What's their primary concern is who's going to take care of the child. So you want to name a guardian in the will. So let's fast forward 10 years. Do you think they've updated that set of instructions? No. Let's fast forward 20 years. Think they've updated that set of instructions? You know, I've seen them as old as you can. I don't know the oldest I've seen, maybe 40. You know,
Yeah,
really.
it's
Like I've
early
seen, I know I've
70s,
seen
yeah.
wills that are older than I am. So you know, that's something. Chances are their lives have changed. The set of instructions has changed. Their financial picture, their children, their family, whatever has changed.
When doing this updating with people, you know, who've come in to see us for the first time, they'll look at their existing will and they'll laugh. It goes, yeah, you know, my ex-sister-in-law is the guardian for our kids. You know, I haven't spoken to her in 20 years now because you know, she's remarried now 15 years. That kind of thing.
Can I ask you a question?
Oh,
Does
sure.
that hold true to legally?
I think so, right? An ex-sister-in-law?
In other words, if you make something up now and then 20 years from now, like we're just talking about the babysitter, does that hold legally?
Yes.
Yeah.
It's still a legally enforceable instrument.
The only exception to that is like if you're married and you do wills together and then you get divorced, they treat your prior spouse as having predeceased you, so you know.
But it still may
for
provide
everybody
for your
else,
sister-in-law.
for in-laws you may have had a falling out with, too bad. They're still it.
Yep.
Yeah.
So the point of this is you can't just rely on your original set of instructions, and you can't just wait. You can't just decide when you're going to come in to do estate planning and to maintain it, because no one wants to do it, right? No one wants to spend the time, the treasure, or otherwise to do this. So if you know, just like you don't like going to the dentist necessarily, but you know you need to do it for keep your teeth in your mouth, right? We want to make sure that through the planning process, that as your situation changes, as the laws change, as our experience changes, your planning is kept up to date. We're going to talk more after the break about the updating program. And before we take our break, we'll spend another 5 minutes and we'll take our break. Another form of contractual ownership is a trust. We're going to do a little teaser about that. Trusts are the bread and butter of a general estate planning practice, because we do trusts in everything we do. We do them in our wills, we do them as living trusts, we do them as revocable trusts, we do them as irrevocable trusts, and we're going to go into the little differences of that. This slide represents a revocable living trust. A trust is simply a contractual arrangement. When you open a bank account, John Smith and Trust for Robert Smith, that is a contractual instrument. You're signing a little card with the bank that creates a contract that the bank is going to honor your dispositive wishes. Now, this is just a little more formal, lengthier contract that you're doing with your own personal lawyer to create a more comprehensive trust that not only deals with your bank accounts, presumably, but other assets that you own.
So then would you define a will as a contract?
Will is not a contract. It is a statutory instrument.
Okay.
So that is an exception to that. One of the advantages of a trust, among others, is that if you do a will in New York, it won't necessarily be honored under the law of, say, Florida, because they have different execution requirements. Florida requires witnesses and a notary. New York only requires witnesses, for example. A trust as a contractual instrument is entitled under the United States Constitution to what's called full faith and credit. So a contract entered into New York is valid in Florida or Alaska or you know, South Dakota. It doesn't matter. So this trust, the revocable trust, there are really two flavors of trust. There's revocable trust and irrevocable trust. There are many varieties of irrevocable trust. One that we will talk about tonight after the break is the Medicaid Asset Protection Trust, the most common one we use. But there are other types. There's charitable trust. There's supplemental needs trust for disabled beneficiaries. There's charitable trust.
Life insurance
trust, that's the other one.
The Cupert I mentioned earlier is a type of irrevocable trust.
Right.
I mean, they go, you know.
We're not going to talk about any of those. Or else we'll be here for 5 hours rather than 3 hours, right?
And you'll be asleep by the end, I promise.
So the main trust we're doing here is the revocable trust. And the revocable trust is a bucket. So this is our bucket here. We're going to create our bucket. It's going to hold our assets during our lifetime and have instructions to take care of ourselves and our loved ones under the definition of estate planning. The person creating the trust is what we call a trust maker. Many documents call it the grantor, but that's, you know, sort of old-fashioned language in our view. Trust maker is the one creating the trust. That would be you if you're doing it.
Believe it or not, we try to dispense with the legalese as much as possible.
Correct.
You know, you're going to have to, you know, deal with a little bit of it. We can't avoid it, but some of it we can, and that's where that's one place we can.
The person who's in charge of operating the trust during your lifetime is called the trustee, and it could be more than one person. And the people who can benefit can be charities too, but the people or charities, institutions who can benefit from the trust during your lifetime are the beneficiaries. So think about this. You're creating a trust during lifetime as the trust maker. Who do you think would be the person or persons who would be the trustees while you're alive and well? No, not us.
Yeah, I don't want that job.
Who else? Remember our definition of estate planning? I want to control my property while I'm alive and well. That should be a tip-off.
So you?
It's you. You're going to be the trustee.
You can be the trustee.
If you're married, who else might be your co-trustee?
Spouse.
Spouse, probably, right? Very often the case.
So you can be you can be the trust maker and the trustee.
In fact, that almost always is going to be the case, yes. In a revocable trust. Now, some irrevocable trust, that would not be the case.
Only with the fancier tax planning ones can
Yeah.
you not be for tax
Right,
purposes. But
right.
that's,
And who are the people who you're going to say can benefit from your assets during your lifetime while you're alive and well?
Could be your children.
And even before that. You're still alive, right?
Yourself.
Yourself. That's my bucket. I can take whatever I want out of my bucket, right? And I can also, if I feel like it, give some to my wife, right? And I can take care of my kids.
if she tells you to.
I can take care of kids. I can. Anyway, you can put whoever you want as a beneficiary because who gets to make the decisions? You do as the trustee. All right?
That's a living trust.
That's a living trust, right?
Yep.
While you're alive and well.
It's a revocable living trust. You can have irrevocable living trusts too, and we'll talk about that.
Correct. So even though you get to, you're really in control and you do everything you want with your property, upon your death, who owns the property? Do you own it at that point? Who does?
You're playing guitar with Hendrix. You don't know
You're the
anything.
trustee.
Well, yeah, technically the trustee, but the trust is the instrument that owns it. So are those assets probatable assets at that point? The answer is no, because it's in the trust. Remember, probate only applies to individually owned assets. If it's owned in a revocable trust, do I own it anymore? No. Do I control it, though? Yes. So you get the best of both worlds. I get to control it, and I don't own it, so it's not a probatable asset when I die. That's one of the appeals of this instrument, right? Is that we get to avoid probate, but in a way that makes sense.
And you control it by what was put into the documents or
Correct. The instructions that are
Way they were
contained
set
in
up.
there will control that. So what we're going to do, we're going to take a nice 10-minute break. So let's take a full 10 minutes here. Stretch your legs, get some refreshments, use the restroom, and then we'll pick up. And we're going to talk about the progression of the trust, then get into some Medicaid planning, and then talk about our process in our office. So thanks for being really attentive so far. We're going to pick this up a little after 4:30.
Okay,
Thank you.
thank you.
Okay, so I think we'll get the show on the road again. Thanks for sticking it out with us here. So we talked about the sort of the basics of the revocable trust structure on the front end here. So what happens, well, husband and wife, we talked about, traditionally we would do separate husband and wife revocable trust. We're doing more and more joint revocable trust planning because with the change in the estate tax rules and not having to do as much estate tax planning, not that you can't do estate tax planning within a single trust, but it is more complicated to administer after the first death, in our opinion. But in most cases, when we don't have to really worry about estate tax planning anymore, especially with the increase in the New York State estate tax exemption, doing a joint trust is simpler in most cases, especially for funding.
So we get a general idea from it here, but everybody's case is different. But so we'll see how it pans out.
Right, but whether it's a joint trust or a separate trust, the spouses are almost always going to be co-trustees with each other. Again, there's some exceptions if one spouse is dementia already, or it is they're separate, blended marriage, second or third marriage, and they have separate economic lives, then they may just be their own trustee. Again, case-by-case basis. This slide really represents sort of the life cycle of the trust plan. We have the husband and wife separate trust in this example. Again, during the alive and well phase, they're co-trustees. But what happens, and this goes back to our definition, if the spouse becomes incapacitated, the first, either spouse, in this case, as we always pick on the husband, sorry there, Ron, we always do that. Husband is disabled or incapacitated. Life and death is a fairly determined event, or defined event, with a exception. I like to use Weekend at Bernie's, where the guy, they thought was alive, but he was really dead. Austin likes the zombie apocalypse example. But in any event, with those relatively unusual
Narrow
examples,
exceptions,
narrow
yeah.
exceptions, you're either alive or you're dead. Not a hard thing. But disability or incapacity is not always clear-cut. We have many times, you've probably seen this in your own personal lives, you know, whether it's with a parent or a sibling or spouse, where the person is in a decline, but you don't know exactly when the right day is that they are no longer able to manage their affairs.
Mm-hmm.
So to help...
Often it isn't, you know, the defined point in time. There are good days, bad days.
Correct.
Some days when they're lucid but can't express themselves. Think, you know, it's...
Yeah, and, right.
Right. So we have a disability panel, because if you have no planning in place and there's a period of time where someone is dangerous to themselves, either financially or from a physical standpoint, the only legal option is to file a guardianship, which is a New York state governed under what's called Article 81 of the Mental Hygiene Law. And that's a very formal legal process. You have to file a petition and serve all kinds of people, and it's a very big mess, right? And you're being ultimately adjudicated by a judge who most likely you've never met in your life. Wouldn't it be better to have a group of people who know you and have known you forever to make a decision that your bad days now outweigh your good days?
Mm-hmm.
And who would most likely be as part of a typical disability panel, might you think?
Children?
Children, and who else? Spouse. Right.
Mm-hmm.
A doctor, typically, we call it your attending physician. Yeah, so you can say, I have my spouse, my 2 kids, and my doctor. If they all say, I've lost it, I may not agree. And we have cases, I'm dealing with one, a family. I did a plan for a woman back in 2006. Now her kids came to me just on Friday. And you know, we went through a scenario where it looks like they're going to have to bring in the disability panel. She's starting to be, you know, a little dangerous to herself, but they say she's very resistant. And so I say, yeah, listen, she may not agree to take away her authority, but when we did this planning in 2006, she agreed that if you all agree with her doctor that she's no longer able to manage her affairs, then that's the rule. And that's how
So
it
in
works.
other words, that's built into this particular
yes.
vehicle? That
Correct.
that whole disability aspect is addressed in this revocable living trust?
That's
what you're
correct.
talking about. Okay.
And that's what really, one of the things, I'll get to your point in a second, that's what really helps set us apart as a benefit over the will. A will only deals with your assets at what time? When you're dead. Has nothing to do with incapacity. Here we have an actual customized process that you create, you know, with our assistance, to make sure the right people are making the right call at the right time.
Just one doctor can make a decision on a disability?
They could, and unfortunately, a lot of sort of the boilerplate trust agreements we see say if a doctor says I'm disabled, doesn't say what doctor it is, your kid may have it out for you, and they hire their best friend who's a doctor who signs a certificate.
One
Right.
person.
Right, but that's not what we're talking about here. Here it's a group of people. Has to be as many people as you want to incorporate into the decision making. We always like to have a physician part of
The family
this.
counts then, that's what I'm
Correct,
saying. Okay.
absolutely.
Yeah.
And don't you
As
think...
long as you want them to.
Right, right. And doesn't that seem more comfortable for most people? I think you would probably agree with that, right? So either you have a period of incapacity or not, and of course, if the panel has said you are incapacitated based on whatever terms you set up, then you will have a disability trustee or trustees who will then take over from you. If you're married, it's probably going to be your spouse initially. If either that spouse is incapacitated or you're a widow or a single person, it'll be probably one or more children. When I say probably, because you may, during the counseling process, we discuss all your children, and we may mutually agree none of them are suitable for doing this, either because they're too far away, they're too busy, or they're not capable because they're very bad with money. All these kind of things come up. And so then we have to find someone else, or a financial institution like a trust company. We can come up with a solution in this context. And then what happens, you either have a period of disability or not. You're going to die at some point, right? And so at the first death, we're going to allocate assets not directly to the surviving spouse or even to a revocable trust, but into some other form of trust, typically what's called a marital trust, or in rarer cases to a family trust. And the next slide, I think, sort of breaks out the We have a little formula that we call a Clayton election. We used to spend a lot more time on this section because of the estate tax implications. We're not going to really spend a lot of time on it here today. Bottom line is, unless you have a large estate, meaning $5 million and up, it's almost no, this family trust is never going to be funded at all. It's going to all go to marital trust.
X this out and not
Yeah, not too much worry about that. If you have a taxable estate, we'll deal with that as we go to it. But most often, the assets are going to go into a marital trust for the surviving benefit, the surviving spouse's benefit. Why to this marital trust rather than going to the surviving spouse's assets? Because we want to make sure if we're the one who goes first, we're on that cloud, we want our spouse to have use and access of these assets in most cases, right? So we go to this one. We want the spouse to have access to these assets and be even the trustee. But if they were to remarry, we want to often put some kind of control on that. Saying, hey, if my spouse, falls head over heel with some schlub and decides to give him all of her assets, that's her business. I can't stop that. But darn if she's going to do it with my assets. So we're going to tie up this trust and say if my spouse remarries, for example, and does not have a prenuptial agreement in effect that would effectively bar that other spouse from exercising that right of election, because you can waive it, but it's got to be done in either a prenuptial or postnuptial agreement. We want to build some controls, because if you're on your cloud, you can't control what they do except for what you've done during your lifetime. And that's what this is all talking about here.
And another way of putting it, too, is that it often isn't about necessarily saying, well, I don't want them to get remarried, so I'm going to do this to try to prevent that. It's not that. It's giving them a sort of a hook to hang their hat on. So the conversation, instead of having to be the awkward, well, we probably should have a prenup, is the, listen, this is, my first husband, God bless him, this is the way things were set up in order to protect our assets for our kids. So what we have to do pursuant to the trust is just do a prenup saying that, those are sort of off the table if something should happen between us. And that's a much, I would like to think, obviously I'm not in a remarriage position, but it seems like a much better conversation to have than just sort of, I don't trust you, I think we're going to get divorced at some point.
But legally, you don't need to bring the second spouse into the trust, right? It can, that you just mentioned a conversation. There's no legal reason for bringing this person into the trust. It could just be left. In other words, I'm thinking, would it even have to be mentioned at all?
Well, in a way, you're right, because legally, if your spouse remarries without prenup and they get divorced, their spouse would not have access to this. What we're really doing in the remarriage is making sure by forcing that surviving spouse to have that conversation, the prenup should effectively waive not only these assets from that new spouse, but also the surviving spouse's assets in the event of divorce.
Yeah.
Because you're almost always going to have a prenup that says, whatever we came into our marriage with remains ours. And so this fosters that easier conversation, which is all too often not done, because having a conversation about a prenup, even for people, 50, 60 years old getting married, can be a difficult conversation.
Look, I have a financial advisor I do a lot of work with. He's a very intelligent guy, a great guy. I refer to a lot of people to him. He's late 30s, 38, 39, getting married for the first time. Mm-hmm. He just didn't do a prenup.
Yeah, we have a guy.
He's got a reasonable amount of money, and he knows, and he was in my office talking about it with our family law attorney, and he just kind of.
Same thing with
Are you saying that? But you would suggest that for him?
Absolutely.
Do a prenup?
Sure.
Is that would you suggest that for everyone, or just someone with sizable assets?
I think you gotta have something to protect,
22-year-olds should have prenuptial agreements?
Not necessarily in that case. Yeah, right. You're right, because they don't have much.
No, I'm not challenging. I'm just
no, it's a fair call.
On it.
Yeah, that's less likely necessary.
Right.
With a 22-year-old, I would think that you would need one, depending on what they were going to inherit down the road.
But that's a little different. Sometimes,
so
with our planning, you don't have to worry about it.
We get a hold of the parents and do planning for them.
That will
where
avoid
the child
that.
doesn't have to worry about it. Wouldn't mind belt and suspenders in it, certainly, but glad you mentioned it, not us, saying, here's more legal work that you guys do.
Yeah.
But,
What about someone who's living with somebody for years and years? How do they figure in?
That's a good question about how living.
Are they considered spouse?
Generally not in New York,
York, yeah.
but there are some exceptions. New York doesn't
There's
generally...
no length of time then, right?
No.
In a way.
New York doesn't recognize common law marriage.
Yeah.
However, there are cases, and I was involved in one about 25 years ago, where you can, if you are in a, what we would normally consider a common law marriage in New York, which doesn't recognize it, but let's say you go to Pennsylvania on vacation. You spend a week in a hotel, and you sign the register as Mr. and Mrs. Jones, even though you're not Mr. and Mrs.
This is
Jones.
actually the case that happened, right?
Yes, right.
Yeah.
This is a case we're involved in. You come back to New York, then the husband died. Mr. Jones dies. The widow, who's not really a widow, doesn't get anything under law, right? We were able, in our case, we represented this woman to show that because they went to Pennsylvania on vacation, and the case law is very clear, if you hold yourself out as husband and wife in a state that recognizes common law marriage, even if you have never married in New York, you can still be deemed a surviving spouse and exercise that spousal right.
You guys put that down anyway. I mean.
Yeah. So anyway, there's a lot of, it's not that clear cut. I don't want to get off track on that.
Right.
But the other thing that's valuable...
Does that mean they get a slice of the pie?
Yeah, that's a good point. The other thing that's valuable, let's say there's never remarriage, but let's say the surviving spouse is, you know, let's say the husband was the one who always paid the bills and handled it, and the wife never really figured all that out. She forgets to pay the car insurance premium. And someday she gets an accident, serious injuries to the other driver, finds out she's not insured, gets sued for $1 million, $2 million. Well, her own assets, going back to this picture here, her own assets, whether in a revocable trust or in her own name, are fair game. But the assets that have passed into the marital trust, or in the rare case, the family trust, are protected against creditors, because these are considered irrevocable trusts and are free from the claims of creditors of the surviving spouse. So even if there's never a remarriage issue, you're adding additional legal protections that is otherwise not available if she is the surviving owner. All right? So let's move ahead to, now we've dealt with if you're a married couple, how do you plan for the spouse. Now we're going to deal with how the assets will pass to your kids.
Okay. So the idea here is, and we kind of touched on it earlier, but again, we're going to talk about it in more detail, is, well, the kind of thing how do I put it? The earth-shattering concept you're going to have to think about is that ownership, or let me put it this way, control and access, that's what we normally think of when we think of ownership. I want to be the owner of this because I want to have control over it. I want to use it for what I want to use it for. I want to be able to access it when I want to access it, so I want to be the owner. Well, you don't have to be the owner of something to have full control and full access over it. So when we talk about a beneficiary, whether it be a child or whoever else it might inherit from you, getting the inheritance, you presumably want them to have full control and full access, but they don't have to be the owner to do that. And by the way, there are a bunch of benefits to not being the owner.
Right. Before we get to the ultimate disposition, this just visually shows you sort of the natural progression of assets, either from the marital and family trust of the deceased spouse, and then the second to die. All the assets will flow down to child 1, child 2 in this example.
Yeah, we're not talking about 3, 4 different trusts for the kids. We're talking about one for each.
Right.
And that's what we're talking about. Is here's the sort of the spectrum of options you have as far as a child or a beneficiary inheriting from you. Over on my right, your left, we have the outright kind of options. Lump sum, meaning just, you know, you're administering the estate, and if it's my family, they write a check to me, Austin F. DuBois. And I just go and put that in my bank account. Phases and stages, that's stuff like, you know, they have the first half at 25, and then the second half at 30, or stages, it's rarer, but you see it, something like graduating high school, buying a house, getting married, that sort of thing. But what's common between all of them is that they're getting it right, outright in their own name. And the way I sort of explain this, the way I like to explain it, is it's like a toothpaste. I use the toothpaste in a tube analogy. So say I'm going on vacation with my girlfriend, which I am in March, and Michael almost ruined the surprise last night.
Oh, is that? Oh, no, okay.
Anyway, I digress. And she says, you know, honey, I forgot my toothpaste. Can I have some? And I say, sure. So she holds out her hand, and then I just squeeze all the toothpaste out into her hand. Okay. First of all, she'll probably smack me upside the head with that.
What a guy.
Yeah. No, I've given her the toothpaste, right? And she can use it, but it's hard for her to protect it herself, you know, to preserve it for the future, even though she does have immediate access to it in full control. She probably would have much rather I just gave her the tube of toothpaste. Or in a situation where we're talking multiple kids, their own individual tubes of toothpaste. They're the one holding on to it, and they're the one taking the cap off and using it whenever they need to. But you've given it to them in a way where it's protected. They don't have to do anything more for it to be protected. And that's what like a lifetime protective trust is. When we do our planning, when we're talking about anything resembling real money, the beneficiaries are getting it in a trust share, you know, their own trust share. They don't have to talk to their siblings about it or anything like that, that they control. Now, of course, if you don't want them to have full control, that's fine too. My sort of purpose in saying all this is saying, look, they can have full control and have it still be protected in trust. If you don't want them to have full control, we do that too, you know, on occasion that does come up. Sometimes it is in their best interest. We have what we call a conservative lifetime trust. The idea is they would not be their own trustee in that case. When it's their own trust and they have full access and control, that means they're the trustee, they call the shots. If you don't feel that they are responsible enough to call the shots, I dealt with a case once where it was a woman who was leaving money to her sister, and her sister's husband was overbearing about finances. So even though her sister was fairly responsible, she didn't want to leave it to her to be fully controlled because, you know, she just buy her husband a Ferrari with it or something like that. The idea is we can restrict it more if you want to. Finally, on the farthest end of the spectrum is a special needs trust. So you have somebody that's going to be inheriting from you that's eligible for government benefits due to some sort of disability. They just aren't allowed legally to have control over it, even though they might very well be able to do so. One of my longtime clients has spina bifida, and his dad set up a supplemental needs trust for him because of the spina bifida, he's eligible for government benefits. The guy's an actor out in California. I mean, he's fine. You know, he's mentally smarter than most people. But because of the fact that he stays eligible for government benefits, he's got a supplemental needs trust that he got inherited from his father.
That's a good time to interject about, sort of bring us back to our cloud story, about why things don't work. You know, sometimes, of course, talking about like the case in Austin with the spina bifida client, we know that person has a disability at the time we're doing the planning. But many times you're leaving for a child, and it could be years after you die that they develop some form of disability or have a catastrophic accident. At that point, if they've inherited everything in their name, those assets they have are going to potentially and likely cause them to be ineligible for government benefits till they spend down their money and have no money left. Then they get on Medicaid or SSI. If we set up a lifetime protective trust that says if they're, you know, if they are really responsible, or you know, we're going to give them full control and access, as Austin mentioned. But we always put in a proviso, a contingent supplemental needs trust that says if at any time after the establishment of a trust for any beneficiary, that beneficiary it becomes disabled or is otherwise qualifies as a special needs person, in that case, then their trust will automatically convert into a supplemental needs trust that is funded with $1 or $10 million. It doesn't matter. Not a single dollar in that trust will count against their eligibility for government assistance. But if they've already had the toothpaste squeezed in their hand, you can't put it back in the tube to become eligible for government for a supplemental needs trust.
Okay, and the way that lifetime differs from the conservative is that the lifetime, right at the outset, the beneficiary is controlling, whereas in the conservative, you could say the beneficiary would never control it.
Correct.
Right, exactly.
You can set those limits.
And you can do hybrids too, by the way.
That's a
This
good
really
point.
is a continuum. I've done some that are sort of in between here where the parents wanted the beneficiary to have control over some assets, say like 5% of their inheritance a year, but then have the rest not have access to. You know, so it depends. Again, it's a case-by-case scenario.
Can the can the specification be even as specific as what the funds could be utilized for?
Sure.
It can be, yeah.
Yes, you can be that
So
specific.
it could be specified
Like
for, say,
education
House,
only,
yeah.
or yeah.
Home
Like we
purchase?
have clients I'm doing that for right now. It's primarily for household stuff and like a car.
Or
And then there's a
education.
little like stipend that they're getting, yeah.
So this leads to an interesting experiment. You know, you get around the holiday Christmas tree or menorah or whatever, the Kwanzaa sticks, I don't know what they are, for whatever particular thing you do. The Festivus pole, you know, get rid of the.
Yeah.
So you do all this, and you say, kids, I have, you know, adult children you're talking about. I have 2 ways I can leave an inheritance to you. Which one do you like? Say it this way: I can leave it to you outright, or I can leave it in a trust for you. That's all you say. What do you think they're going to choose? Outright, right?
Mhm.
How do you say, I can leave it to one of 2 ways for you. I can leave it to you that it's immediately accessible to you, but if you ever get sued, divorced, or sick, you can lose it all. Or I can leave it to you in a way where you can access it and use it for whatever you want. If you ever get divorced, you ever get sick, you ever get sued, the money's protected. Which way would you prefer? Isn't it interesting? The way we phrase something totally changes the result. And that's what we've done. We described the trust in the second example.
Absolutely. And I was talking about the kind of conversation for the remarriage before, but it's the same thing for a lifetime protective trust. You know, let's say, you know, this is relevant. I have a pretty serious girlfriend, so say my parents leave me assets. If I'm married, do I want to say to her, well, listen, honey, you know, I talked to the lawyer and I'm getting that check written to me, so I'm gonna just put it in my account over here, just in my name, because you know we might like get divorced at some point. You don't want that. You don't want to have that conversation. I'll be sleeping on the couch, or I will be getting divorced.
Yeah, that's right.
Soon,
Yeah.
Disengaged, yeah, never engaged.
If it's lifetime protected trust, the conversation is this. Oh, so you know, I got off the phone with the lawyer, and they're doing the rest of mom or dad's estate. And you know, look, what they've actually done is they've set it up with this kind of trust where I can do whatever I want with it. You know, we can use it to go on vacation next year, we can do whatever. But look, if I ever get sued, if I ever have a catastrophic health event, it's protected. Isn't that great? And she says, yeah. I don't mention the divorce.
No, you wouldn't
part of
mention
it.
that part.
And I'm not lying. I mean, it
Yeah.
is protected against, you know, regular lawsuits and catastrophic illness. A divorce is sort of the same legal proceeding where it would be off the table that I just wouldn't happen to mention at that point. But that's what it is. It's making that conversation better for the real world with your beneficiary. And
Right.
again, that's what we're trying to
Right.
do here.
So some people say, and logically so, this seems too good to be true. You mean my kids can access the money and still have it protected? Well, certainly under New York law we can do that. There are 2 provisions of New York law here. One is from the Civil Practice Law and Rules that says that property that is left in trust is protected if the beneficiary didn't create the trust or put the property into it. So that definition, will it protect you against your own creditors for a trust you funded yourself? The answer is no, because it doesn't meet that definition. But if you set it up for the benefit of a spouse or a child, will it protect them? The answer is yes. And
They didn't set it up, you did.
Right,
They
and they
didn't
didn't
put money
fund it.
into it, it was funded with your stuff.
Right. So this is clear on the civil practice law. Under a provision of the estate powers and trust law, a beneficiary can be his or her own trustee and make purely discretionary distributions to him or herself without violating the creditor protection aspects. So that's where the person being their own trustee comes into play.
So protected,
And
and they can do what they
accessible.
want with it.
Yep. Now, some people say, well, I really like the idea of a trust, but I really like to protect the assets against my own creditors. Now, we can't protect you against current creditors you have. That would be fraud, both on your part and our part. However, if you don't have creditors currently, and you do some protective planning, and this would require what's known as a self-settled trust established in asset protection states. The most prominent here are Alaska, Delaware, Nevada, and Wyoming. Those are the states that have set up statutory scenarios that you can establish a trust under the law of that state. You don't have to live there or even set foot in that state ever. I set up Wyoming trust quite regularly. I've never been there, nor have my clients. And that trust, properly structured, can protect your assets against your own creditors, and you can be a beneficiary. You can't be your own trustee. So this is a popular tool for like physicians, business owners, and things. People have higher risk than the average person. So it's really a little bit beyond the scope of our program. That's more advanced planning. But I just want to point out to you that there are options for those who really do want to create asset protection vehicles for themselves.
And it's important to understand that when we do trust planning for you, it's not creditor protection. You know, it's protection against perhaps, you know, long-term care costs, nursing homes, that sort of thing. But if you get sued, the stuff we're doing here for you, that's still on the table unless we do some fancy higher-end stuff like this.
So, you know, do all these instruments, do they come out of legislation? How are these
Some
created?
do.
A lot of these instruments
Yeah.
created?
Some are legislative and statutory.
State and federal?
Almost all state.
Okay.
Trust planning, there is something called the Uniform Trust Code that's been adopted by a number of states. New York is not one of them. That has tried, there's a uniform commissioner of laws that try to get together and create laws that they think should apply pretty much on a national basis. Each state, though, has to adopt them. Even the uniform laws that are often adopted, the legislatures in the state will make significant changes. So rarely you'll find a state that totally adopts the uniform law. And New York has adopted some, but not the trust code. We haven't adopted the trust code. So let's talk about IRAs for a second. For a lot of years, there was a controversy whether an inherited IRA, a beneficiary IRA is often called, is protected against the creditors of the beneficiary.
And why would people think that? And now we're not bankruptcy attorneys, but the general idea is that if you do file for bankruptcy, apparently to a large extent, your own retirement accounts are not part of that proceeding. Like you can keep a lot of your
Yeah,
retirement
you kind of
accounts.
referred to said that in the beginning.
Right.
Maybe.
The IRA was one of the protected.
Right.
Sure.
But what happens if it's an inherited IRA? Well, in June of 2014, so a little more than a year and a half ago, or a little less than a year and a half ago, I should say, the Supreme Court ruled, and this was a 9-0 decision, you don't see too many of those these days at the Supreme Court, in a case called Clark versus Ramaker, that an inherited IRA is not protected from the reach of the beneficiary's creditors.
Right. So if you die and then your kids inherit your IRA, it's IRAs are different. If you're not familiar with them, what happens is it's not like if you die with a bank account, your kid just gets that bank account. When you die with an IRA, then your child then just has to start taking distributions out of the IRA. The account, in a weird way, sort of stays in your name. What the heck is going on? It stays in your name as a deceased person, and your child then just gets distributions out of it.
Yes.
So it's the whole theme here that we're getting into is how retirement accounts have a lot of different rules. So in that position, the beneficiary of an IRA, Clark v. Ramaker said, you know what, that's not protected like it would be for the person.
And the rationale of the Supreme Court was this. It didn't apply to spouses. A spouse who inherits an IRA does have the same protection because they can do a rollover and defer taking distributions till they turn 70 and a half.
And they can roll it over into their name?
Yes, a spouse can, but no one else can do that. Now, a 40-year-old child who inherits the IRA, they can't defer. Even if the parent hadn't been taking distribution yet, they're 68 when the parent dies, so they haven't reached their minimum distribution age and haven't taken any distributions yet. As soon as that parent dies, the child who inherits has to take a distribution that year. It's a small distribution because it's based on their own life expectancy. But the Supreme Court ruling was because the law says a child or a beneficiary of any age, could be a 1-year-old grandchild, has to take the distribution out, it can no longer be really considered a retirement vehicle, and therefore it doesn't get the protection of like an ERISA retirement plan. So what's our solution to help protect those assets? Because most people name their spouse as primary and their 2 kids, Joni and Susie, as beneficiaries.
Right. And you can't put a retirement plan into a trust.
Right. When you own it.
You can't change the owner of it to anything. It has to be you individually. Otherwise, it's a big taxable event.
how do you
Whatever the
protect that?
value of the IRA is,
Right.
you just get income for the year.
Right. So what attorneys will do, who know what they're doing, will create what's called a standalone retirement plan trust that will act as a contingent, typically a contingent beneficiary, or if you have no spouse, a primary beneficiary of your IRAs and retirement accounts at your death.
So instead of your kids being the direct beneficiary of the account, your kids will each have a separate trust share under this retirement plan trust, which will be the beneficiary under the retirement plan account, and they'll take their distributions through that.
Well, I don't want to take too much time on the question.
Well, let's see if we answer
hold
your
your
question.
thought, yeah. So this slide represents a structure of a typical standalone retirement trust. So we have a guy, Archie, who has $1 million IRA. His wife is Olivia. Archie, once he reaches 70 and a half, has to take requirement minimum distributions based on his life expectancy under the Uniform Life Table. Now he dies. Olivia was named the primary beneficiary. Now, if Olivia was his second spouse and not the parent of the children, probably have a different conversation. We'd probably create a trust for Olivia as a beneficiary. But in this case, let's assume it's a first marriage. She receives it, or she can do what's called a disclaimer. And instead of having their 3 sons, Cooper, Peyton, and Eli, as the individual beneficiaries, what we've done is create a standalone trust with a separate share for Cooper, a separate share for Peyton, and a separate share for Eli. Under this scenario, each of the 3 sons have to take required minimum distributions over their life expectancies. Cooper's the oldest, so he'll have a slightly faster payout requirement. Peyton is the middle child, a little bit less, and then Eli, the youngest, takes even the lower amount over the course of his life. But what happens is it's not paid to them individually in their names, it's rather paid into a trust, so they avoid the negative result of the Clark versus Ramaker case.
Right. They still get the creditor protection. And by the way, they get to keep taking it out by their own life expectancy.
Right.
If the trust doesn't look right, and that's why we do a separate kind of trust for this, you know, someone, you know, they might say, well, why don't, you know, if Archie has a regular revocable living trust, why wouldn't we just name the trust shares of that? And the answer is because retirement plans are so drastically different than every other kind of asset, pretty much. We want to have, look, again, I said we have computers, right? We just want to do a separate document that is tailored specifically to retirement plan rules.
Trying to force the IRAs into a standard revocable trust share for a child is a little bit like doing the square peg in a round hole. It can possibly fit, but not really well. Now, if someone comes to us with a $10,000 IRA, are we going to do this? No, we're not going to do this. Usually, you know, we're saying a couple $100,000 above is probably the break point where it's worth doing this.
What would you do with the 10,000?
Just name the 3 kids individually. You know, so if they're going to inherit 3,000, if they're going bankrupt, not going to be helpful in a trust anyway. Yes.
Do the same rules apply with the 401k?
401k is a little different. We still use the structure for that. The good news is, though, an inherited 401k is protected under a federal ERISA law, but many times people will roll those out into an IRA when they retire. So we don't want to just take the chance that they're going to keep it in the 401k. Maybe it's not the best investment option. So using a standalone trust will apply in either case. Not legally as necessary with the 401k, but the practical effect is the same. So now we're going to talk a little bit about we sort of taken our world out of the estate tax concerns, where the rubber meets the road in so many of our clients, virtually everyone has to deal with this one way or another, is in preserving our assets in the event we need long-term care. And so we're going to talk about, we use the term generically Medicaid planning, because the idea is Medicaid is one federal program that is available to anyone, but with certain strings attached. A knowledgeable elder attorney can help walk people so that they can become eligible without breaking the law, and most importantly then, without having to spend all their assets till they become poor to qualify for Medicaid. So with that in mind, we're going to take you through the process.
All right.
I'm going to grab a seat because I'm getting a little tired.
So as Rich kind of just said, but I'll go in a little more detail, there are only really 3 ways to pay for long-term care. You can pay out of pocket, so you can just spend 13 grand a month, whatever it is, on a nursing home or even on someone to come in and help out. And even if your level of care isn't that, heavy, say 7 grand a month, 8 grand, I mean, it's big numbers. And we don't want to be necessarily going out of pocket for that. If you have long-term care insurance, that's great. Not a lot of people have it. Very few, really, people have long-term care insurance. Only now is it becoming more popular, and it's also becoming more expensive and harder to get. Back when it was affordable, people didn't know about it as much. And there are some people that do have it, and that's great, but again, very, very few people. So that's the second way to pay. Medicare is not a way to pay. Yes?
No, I was just asking you on the long-term care insurance. As part of, say, your advice to clients, do you normally recommend that long-term care insurance?
Well,
or do you look at it?
We're not financial planners or insurance agents, but we certainly recommend having that conversation. Look, financial planning when it comes to estate planning, financial planning, having an accountant, you do want to have when you're talking about retirement income and long-term care planning, you would want to talk to somebody about it. Long-term care insurance can be a great thing. Like I said, the people that I've worked with that have it, our options are a lot better. Sometimes what would normally be an emergency situation is not such an emergency if there's long-term care insurance to cover some expenses.
So this conversation.
So I can't recommend. I recommend absolutely considering it. Yeah.
Yeah.
Because it's a tool. It depends on what you need to get built.
If it's not in place, or if it's not an option for someone, that doesn't mean the end of. No,
that's why this is very applicable, because a lot of people just don't have long-term care insurance and aren't going to get it, or would be able to afford it, because it's just very expensive now. Medicare does not pay for long-term care. It maybe will cover up to 100 days of skilled care, but they can cut you off sooner, and 100 days isn't really long-term, right? And regular health insurance just flat out doesn't cover it. No. So the third option is Medicaid. Medicaid does cover long-term care. The caveat is that you have to qualify for it financially. It's a safety net program. The good news is there is a robust law about it saying ways that, I'll call it the middle class, can qualify for it. People that have savings, people that aren't below the poverty level. There are things you can do, types of transfers you can make, and ways you can protect your assets. The law allows for it. They permit it. This has been going on. This type of Medicaid planning has been going on for at least 20 years. Which is actually relatively new in the legal world, but which makes it kind of fun for us because we can be creative. But here's what we know. So in New York State, we have one of the best states for Medicaid, by the way. We don't have there's a lot of things we can complain about in New York State, but some of those heightened taxes are going to increase Medicaid benefits, which do help out some of my clients. We have a resource limit. So what that means is any kind of countable asset, money in the bank, cash value life insurance, investments, real property that's not your primary residence. Your primary residence is not totally off the table. They just won't deny you Medicaid for having one. Retirement plans, the retirement accounts, the principal of the retirement account doesn't count against this, but the RMDs you take do count against the limits on income. Before I get to income, this is the 2015 limit on resources, $14,850. The 2014 limit was $14,550. Year before that, it was $14,400. Year before that, it was $14,250. Year before that, it was $13,800. The year before that, I was practicing in Philadelphia and South Jersey, so I don't know what it was in New York. Sorry. In New Jersey, the limit's been $2 grand for a long time, and it's not changing. Yeah.
So even New York's number is very low,
I have clients that have lived in North Jersey with family in New York, and I tell them move to New York when it comes to long-term care planning, because getting Medicaid in Jersey is much harder. But as we get to, and so this is going to go up a little bit next year, maybe 150, 200 bucks, something like that. Maybe less, actually, because inflation's so low. But you get the idea. It increases a little bit every year. The income limits. So for community Medicaid, if you're not in a nursing home, there are two types of Medicaid. There's community Medicaid, there's nursing home Medicaid. If you're getting help in the home, or if you're in a certain type of assisted living that accepts Medicaid, the income limit is $825 a month. Now this is also for 2015, it'll go up a little bit next year. That doesn't mean if you make more than that, you totally don't get Medicaid. What that means is if you make more than that, you have to spend the overage on your care, and then Medicaid will pick up the rest. They let you keep $825 a month, and they cover the rest of your expenses. Now, if you're in your home, $825 a month isn't doing you a heck of a lot of good between food and clothing and property taxes and maintenance and everything else, and just general living. There are ways around that. It's called a pooled income trust. We don't really go deep into it here because it only doesn't super often apply, but we can kind of help you out there. We can avoid that. We can allow you to use all of your income essentially, even if you have community Medicaid. But for someone that's institutionalized, someone that's in a nursing home, the limit is 50 bucks a month. They basically, the logic, if you want to call it that, behind that is that in a nursing home, they're providing everything for you, so you don't need income for anything other than to get your hair done once a month or buy a nice bottle of bourbon, which is what I'm going with if I'm in that situation. If they don't allow me to, I'll hide it in my room. Probably shouldn't have said that on camera, but anyway. Those are the resource limits. And as you can see, they're pretty restrictive, right? I mean, you know, if you've got anything resembling a savings, then you're not going to qualify for Medicaid. And if the nursing home or the DSS has it their way, the DSS is the Department of Social Services, they're the county office that processes Medicaid applications. They're going to want you to spend down all your savings. They're going to want you to pay privately until you're under these limits, and then they'll give you Medicaid. Well, we don't want to do that. Those resources limits I just mentioned, those are for the person applying for Medicaid or receiving Medicaid. If you're married, your spouse also has limits if you're going to be applying for or receiving Medicaid. Again, these are numbers that raise a little bit every year. This year, $119,220 is the amount of essentially money, investments, that sort of thing, that the community spouse is allowed to have. The maximum income a community spouse is allowed to have is just under $3,000 a month. The thing about that is that if the community spouse, so, you know, the situation that I'm most often dealing with in, you know, as far as the generation that this is affecting now, is essentially the husband's the breadwinner, and the husband's also the one that needs long-term care sooner, right? The wife maybe makes several $100s or a little over $1,000 in Social Security for income per month, but that's it. What they're allowed to do, the community spouse is allowed to take enough of their institutionalized spouses, the Medicaid spouses' income to hit this almost $3,000 number. So this is sort of like the maximum between the two spouses. But there are cases. The good news is in New York we have something called spousal refusal, which one other thing, Florida has spousal refusal, right? That's it, other than us.
Right.
Where if the community spouse has more than this, and I've seen this, you know, a good handful of times. You do this enough, you see it, where the community spouse has $3-something thousand of income a month or more, and they've got more resources, or we've transferred all the resources to them. They can just say, I hereby refuse to financially contribute to my spouse's cost of care, and they're just allowed to keep their excess resources. It's as simple as that. I will say,
responsible for any payments if you take spousal refusal?
So, usually not, and here's what I mean by that. Spousal refusal just means that they can't deny your spouse's Medicaid application if you have too much money. If this was New Jersey, spouse just doesn't get Medicaid at all. In New York, what happens is they approve the spouse for Medicaid, and then they have the option, they are allowed, the county would basically send you a letter. They have the authority to send you a letter to say, you're over-resourced, we would like you to contribute some of those excess resources toward your spouse's care. And at that point, it's a negotiation process. You know, I've had a couple clients where this has happened, and we get in touch with them, and we get in touch with the county and say, okay, how much, you know, are you looking to get? And we work it out so it's not a burden on the well spouse. They still, you know, they maybe pay a little more for their spouse's care, but they're still keeping the majority of their stuff.
Right?
Well, that's the thing. No. You can't just tell the county to pound sand if they ask you to do that. You got to talk to them, and you got to come to an agreement. If you do, ignore them, then they can sue you under a theory of spousal support, like in family court. Yeah. Luckily, I've never been in a case where that's gotten to that point. But also doesn't often happen anyway.
Disabled person too. In other words, you have a disabled child, or I think the spousal refusal is in on that too. I remember a friend of mine had a problem with that.
If they're a minor, you have an obligation to support. Yes.
Oh, yes. So
yes, you do.
Obligation to support, yes.
So, yeah, that's, I think, that's kind of, in other words, you're not legal, the spouse is not legally bound to contribute support.
Well, they are legally bound,
they
but you
are
can
legally
refuse.
bound, but the way the process goes is that they can initially refuse, their ill spouse gets on Medicaid,
Right.
and the county might get in touch with you to say, listen, you should support a little bit.
So they are legally bound.
Yes.
Yeah.
There is a spousal obligation support which you can reject, essentially.
But with the spousal refusal.
Correct.
Okay.
Right.
What is that called, the spousal obligation support, you said?
Just spousal support obligation,
Yeah.
yeah.
Support
Yeah.
Yeah.
All right.
Okay, let's,
Okay.
That doesn't make any, how much money the person has either. It could be a millionaire, right?
Correct?
Yeah.
The fact is, though, the more assets you have, excess above the exemption, the more likely you're a target for a support action by the
Yeah,
county.
legally, can they, I guess they can sue you, right?
Yes, they will.
Yep.
Okay.
They can, not that they will.
Legally,
Many counties
not-
have not been active in suing.
yeah.
But not if you pursue the refusal.
Oh, no.
You can't-
No, they'll sue you
All
after the
refusal
fact.
does is allow your spouse to get on Medicaid.
Right.
Even after doing the spousal refusal, they can still ask you to
Yeah.
submit to support your spouse.
Right, but they can't refuse your spouse's Medicaid if they if the
Oh, right.
if the ill spouse meets the
Okay.
criteria
Right.
of the asset and income limit.
Right.
Refusal just refers to being able to
Right.
qualify for the Medicaid.
Remember, like I said, in New Jersey,
That's fine, yeah.
your spouse just doesn't get Medicaid at all if you have too much money. In New York, your spouse gets Medicaid, you just have to talk to the county about how much you're going to contribute.
Sure.
All right.
So what happens if you are looking to make gifts, and there are different rules that apply under different circumstances?
So what, the Medicaid laws, they understand, our legislature may not be totally full of geniuses, but they do know that if you say, I'm going to offer a benefit, but you have to have under a certain amount of money, then people are going to try to get rid of their stuff to get on the benefit, right? That's where the look-back period comes in. If you apply for nursing home Medicaid, they ask you to submit to them 5 years of financial records. Bank statements, retirement account statements, investments, tax returns, you name it. They are allowed to ask for it, and if you want to be cute about it and tell them they're not going to get it, they're just going to deny the application. They don't have to grant the application, right? So what they look for when you give them these records is whether you've given stuff away during that time. What they call them is uncompensated, non-exempt transfers. So uncompensated, we realize, is just giving stuff away without getting anything back. You are allowed to buy and sell things. It's uncompensated that they're worried about. And non-exempt means there are some transfers. You can give stuff away to some people, and that's totally exempt. That's fine. Spouse is one of them. You can, unlimited transfers between spouses will not affect anybody's Medicaid eligibility as far as the transfers are concerned. An adult disabled child, you can give all your assets to an adult disabled child and get on Medicaid without having to worry about the 5-year look back. Again, any kind of large transfers, we're going to want to make sure we're doing it in the right way, but these are the laws that are underpinning it.
Right. So one of the most common use of exempt transfers with husband and wife. Husband is the one with ill. They own joint assets. What we do is we'll transfer them solely into the wife's name, get him at below the $14,850 asset limit, do a spouse refusal, voila. They could have $600,000 in the bank. He'll get Medicaid tomorrow.
Right.
Done. All right? And that's very common. Then we deal with the post-eligibility issues that we just talked about.
Right.
So that's the most common use.
But if there aren't exempt transfers, ways to just get essentially money to a spouse or a adult disabled child, there are a few other really esoteric ones.
Minor children, too.
They look for these transfers, and if they see there's been any money given away, money or property, anything of value, again, when I say money, I just mean value, they institute a penalty period. Now, let's be very clear here. It is not illegal to give away money and then apply for Medicaid. It's not. They just disincentivize it. They just say, well, you're going to give away money and apply for Medicaid? Okay, well, guess what? You're asking us to give this to you. We're not going to give it to you for a certain period of time, depending on how much you gave away. So if you gave away $100,000 during the prior 5 years, then they're going to take that $100,000, they're going to divide it by what they say is the average cost of nursing home care in your region per month. Whatever that number they get, it's like 8.4 or something. If it's $100,000 divided by the average cost, the Department of Health says that the average cost of nursing home in this region for 2015 is $11,455. That includes Sullivan and Ulster, so I think that pushes that number down a little bit because around here it's more like 12 or 13. And you can see what it is kind of statewide. It kind of tracks what you'd expect cost of living to be.
Do you have any choice of nursing home you go to?
Well, if you're being,
Like
yeah, I
New
mean,
York
if
State.
You're private
your
pay.
family, first of all, if you're private paying, and secondly, if you've gotten to the point where you need to go to a nursing home, you sort of do. I'll put it this way, because oftentimes someone goes into a nursing home because there's been some sort of precipitating event, they've fallen or they've had a stroke or something like that. They go to the hospital, and the hospital says, look, you know, mom, dad, they can't, you know, it's not safe for them to go back home, so we need to discharge them to a nursing home. And with the family being involved, and as long as there are beds available at the nursing home, you can usually kind of direct them where you want to go. I've never seen anybody go to a nursing home that's just so far away from their home.
Nursing homes, you know, that's
Yeah,
what I mean.
Right.
Exactly.
Well, maybe say the difference between the county one and private.
Right. Well, sometimes there's the differences aren't necessarily you know, what you'd expect them to be. Right.
That's right.
But right. And look, this is again why we always emphasize proactive planning. So your options are as open as they should be.
Right.
Or as you want them to be. So if they institute this penalty period, if you give away $100,000 and all of a sudden you have to go into this nursing home and Medicaid's not going to cover your nursing home care for 8 or 9 months, that means you're racking up a bill of $11,000, $12,000 a month. So you either have to go back essentially and get that money and spend it on your care. If you can do that. If you can't do that, the nursing home is going to sue you because they've got a big bill that's not paid. And they might sue the person you gave the money to as well. Yeah.
Right.
Which is why we emphasize, of course, proactive planning.
Right, and that leads to a more proactive approach. Crisis planning we can do what's called half a loaf plan and preserve. Someone came to us with $400,000 of assets and they're in a nursing home tomorrow. We can save reasonably $200,000 plus of those assets. That still means though $200,000 subject to spend down.
Right.
If you
Not
come
great,
to
but it's better than nothing.
If you come to us well,
And that's last minute.
Right. If you come to us, you're 62 years old in pretty good health, or 70 years old in good health, we can fairly confidently save 80 to 90% of your assets. Technically 100%, but that would mean putting everything in a Medicaid trust, which is not what you're going to do. So a proactive approach is to create an irrevocable Medicaid trust. So a Medicaid irrevocable trust is a trust, like the other trust. It's a contractual instrument, but it's a little different in that you can be the trustee of your own trust, but you cannot have access to the principal assets that you put in the trust.
The reason this works, by the way, is notice we're talking about this 5-year look-back period. You have to provide them with 5 years of financial records. So if you gave away $1 million 5 years and 1 day prior to that, legally they can't give you a flack about it. So that's what we talk about when we talk proactive planning. Transferring your assets, holding your assets in such a way at an early enough time where they're not allowed to give you a penalty period.
Right, so funding a trust now will start that 5-year clock running so that well before you ever need long-term care, if you ever do, the assets are out of the 5-year window, the look-back period has expired. And it's clearly a better choice than outright gifts in most cases, first of all, because you can retain significant control, plus that step up in cost basis issue Austin talked about earlier. An outright gift, your kids will take your carryover basis. In a properly structured Medicaid trust, assuming they inherit at the time of your death, they're going to get the step up in cost basis. Right. So this diagram will show you the mechanism of how this thing works. So we have our little bucket again. You're the trust maker, you put your money, often the most common asset we fund into a Medicaid trust is a house. So this is something you paid 30 years, you finally paid off your mortgage, you got your equity in your house. It's a place to live, it has value, but really you think of it as a place to live, even though it has real economic value. The problem is if you go to a nursing home and you don't have a spouse living there or an adult or disabled child, the Department of Social Services is going to count it as a source of equity. They're going to put a lien on your house, and therefore, while they may cover you for Medicaid, someday the house is sold, they may get all or most of the sale proceeds. So that's a real problem. But if you put a house in a Medicaid trust, you go home at night, the day after you've funded into the trust, you can take out your key, it's still going to work. You're still going to get in your house, but you started that 5-year clock. And that's really important. It's subject to the 5-year look back, so it's going to start that transfer period today. Trustees, in our practice, we don't have any great problem with the client being the trustee. Some attorneys don't have the client. I don't really know why, but in our opinion, actually, so long as the trust has proper restrictive language, it shouldn't put you at any risk. If you do choose other people's trustees, like I had a woman in today, she's 86, wants to have her adult son as trustee, but I told her you can fire him at any time if he doesn't do what you want him to do. Mm-hmm. You're allowed to keep all the income from the trust, because keep in mind, most people doing this are in their retirement years or very close to it. They know what their income is. They got their pension or IRA distributions or 401ks, Social Security, and they want to have their investment income. Many of the people we work with don't even use their investment income. They let it accumulate. But if they want to have it, they can get it. What they can't do is they can't touch the principal. So if you put your $200,000 investment account at whatever, Merrill Lynch or Smith Barney, or there's no Smith Barney, Merrill Lynch, Morgan Stanley, whoever they are anymore, Schwab, Vanguard, you name it, they're all out there. You can't then the next day, even if you're the trustee, if you say, you call up your investment advisor and say, Joe, send me a check for $30,000, then you've sort of blown up the trust. But does that mean you can't really access the principal? Not necessarily, because even though you and your spouse can't receive principal, you can have the trust specify that other people, either a class of beneficiaries or specifically named people, can receive the principal from the trust. Who is the most likely people that's going to be? Children. Yeah, so your kids. Kids or descendants or something else that. So you as trustee can call each of your 3 kids, say, kids, I have good news. I'm gonna being very generous this year. We're gonna write you a check for each for $10,000 out of the trust. That's fine. Then what's shockingly, a month later, you get a note in the mail along with a check from your daughter saying, because you're such great parents, I've decided to give you a gift of $9,500. Right? You never had a conversation with them at the table to say, oh, by the way, we're giving you money. Next month, you're going to write us a check. It just happens to fall out of the thin air that you get a gift from your kids. Now, that's not really what's happening, honestly. It can happen that way. But that is a way, as long as it's done in a kosher manner, I think. Because once the money is distributed to the child, it is their money. They have absolutely no legal obligation to do anything with it other than use it for their own benefit. If they choose to give it back to mom or dad, yeah, you're probably okay with that. So the reality is very rarely will anyone actually need that money, but it is good to know from a comfort level that if there is a way to obtain money, should it be necessary. In a very rare case, we need that. If you do sell the house during your lifetime, some people fund the house. One of the questions we get, can I sell the house or can we sell the house? The answer is yes. And as long as you're living in the house within the prior 2 years from the sale, it will still qualify for the capital gains tax exemption that is only available to a homeowner. For single people, it's a $250,000 gain exemption. For couples, it's $500,000. Now, after both your deaths, if it's a married couple, after your death, if you're a single person, so the trust will act like any other trust. It'll pass assets, into shares for child 1 and child 2 or 3 or 4, however many you have. We're going to create those nice lifetime protective trusts. Now, but what if people worry and they say, well, what if I change my mind? You put us into this irrevocable trust, which is legally irrevocable. You can retain a limited power of appointment, which we often refer to as a power to disappoint. All right? Because even though the trust is irrevocable, you can retain the right to change the final disposition and the beneficiaries. So if Johnny here forgets to send you a Mother's Day card, you can call your lawyer and say, I want to cut Johnny out and leave everything to Sally. All right? And you can do that. Simple written statement or revise your will to exercise the power of appointment. The mere fact of having this power, even if it's never exercised, which in most cases it's not. Most people, when they leave it equally to the kids, it stays that way forever. By merely having the power, this is what makes sure that the assets that were poured into the trust are part of your estate. Under the tax law, the income tax rules, if you have a power of appointment exercisable at the time of your death, then those assets are included in your estate and they get the step up in cost basis. That's the beauty of this whole thing. So we get the Medicaid protection during your lifetime, you have the income access, principal to the descendants, and then you have the after-death protective trust planning just like we did in the revocable trust. So some people say, which one do I need? Well, it depends. Some people will need, really, their situation will call for having both revocable and a Medicaid trust. Some will just one or the other. It all depends on the circumstance. So let's now move into our final sort of topic of how we do a practice in our process in this office here. We have a program, it's a formalized program that we've developed called the Legacy Assurance Program. So our marketing people came up with this nice logo with a nice little tree and stuff like that. So there are really 3 phases and costs that every estate plan has to deal with. There's the cost to create your plan on the front end, or not pay any cost to do it. There's the cost to update your plan, and sometimes a bigger cost to not update your plan because, again, the less updating that is done, the more likely the plan will not work. And then there will be a cost in some manner to settle the estate assets that you have when you pass away. There's really, in the upfront world, there's really 2 ways to go about it. You can do the word processing method if you're going to do any planning, or you can do more of a counseling and design model where you have this more intensive give and take and questioning and back and forth.
And making sure we get stuff right.
Most importantly. Well, why is updating important? Well, there are a number of changes that impact on your plan. We've touched on some of these earlier, but we'll point them out in more detail now.
As if my babysitting story didn't fully explain why updating is important.
Clearly, right. Clearly there are changes in your life cycle and phase. Your personal circumstances would change with, marriages with your kids and changes in your business and your investments and grandkids and divorces, hopefully not, deaths, things of that nature. And your financial picture is going to change too. The laws are going to change. We know that. There's thousands and millions of laws out there, tax laws, they're all changing. Depends on who's in office, what the world economy is like, and all that. And the other thing, the one that's probably least thought about, is changes in your attorney's experience. We've been doing this a while now, me a little more longer than Austin, and a little longer than Megan, and we are constantly striving to improve and enhance our knowledge. We go to CLE programs, we do webinars, and what we don't want to have happen is where we learn something really great or the laws have changed that we need to incorporate in our planning, and we have no process to get our clients who we met with last month or last year or 5 years ago that new information. So as we'll talk about in a few minutes, we do have a process to make sure you and all our clients have a way to keep everything current. Yes?
Yeah, I'm sorry, it's kind of self-evident, but could you just elaborate a little more in the upfront phase, like what, and the counseling design, of course. What kinds of, aside from, I can imagine, the initial interview, does this take place in a couple of steps?
We actually have that all explained in a couple minutes. No,
We'll
you're
get
good.
to
It's
it.
actually a great question because we need to explain it, and we're going to.
So the reality is I think people in the room probably personally recognize people on average wait at least about 20 years before ever revisiting their estate plan. And you can see the pitfalls and the problems that addresses. And also people have trust. Many people now do have more and more. When I started doing estate planning as the primary part of my practice in 1999, trusts were still fairly rare, especially in this area. Now a lot of attorneys and other non-attorneys, frankly, are doing trusts. But the reality is very often they are not fully funded. I'm dealing with a scenario where we had 3 children. Their parents did planning in Florida. I helped form an LLC for them. They own a commercial building in Rockland County. And I set up an LLC, and they had a revocable trust done in Florida. After they had both passed away in their late 90s, I got the information. Their financial advisor basically handled everything. He just had an attorney on the side, I think, cranking out trusts for these people. The trusts were fine, but the attorney had a letter specifically to his client saying, by the way, I'm not doing any funding for you. That's totally your responsibility. So you know what happened? Do you think they got funded? Mm-hmm. Absolutely not. Mm-hmm. So that's led to a lot of chaos now. All right. The settlement phase, some people say, like these people thought and their kids thought, they had this trust, so there's nothing had to be done when they died. Mm-hmm. Dad died a year and a half ago. Mom died this past May. They never administered the estate after Dad died, and they haven't done anything since Mom has died. They wanted to put the commercial property in their names. I said, hold on a second. You don't have authority to do that. In the trust instruments their parent created in 2008, it established generation skipping trusts for each child, which is a whole nother level of tax issue that we got to deal with. And I said, you know, this has to be done according to the instrument. People get these things done all too often, and they never look at them again, and they totally ignore everything they did in the first place, and their kids certainly have no idea what happened. It becomes a complete, you know, cloud story gone bad on steroids, and that's what the case we're dealing with now.
So should the beneficiaries be in on this to know what's going on?
It's a good question. Should the beneficiaries be in on it? We certainly encourage the adult children, to the degree the parents are comfortable, to be participating in the planning or the conversation, or at least become up to date on what's going on even after we initially meet with the parent. We can have a follow-up with the kids or do a telephone call.
What we like to do, and we kind of get to this a little bit more, we do like to have sort of like a family team meeting, but it also depends on the client's comfort level. Some clients just like, look, my kids, they can worry about it when the time comes. I don't want them involved now. And that's fine. Again, we're here for you guys. It does sometimes help to have them involved. It depends.
Right, so these are not magic books. These trusts that we do, everyone gets a nice red book or multiple books depending on what their planning entails. They don't just do things when you die. They don't sprout an arm and a leg and head and run around. People have to be involved to make this happen. It's going to be professionals, it's going to be the family members, and the more coordination there is among everyone, the more likely the plan's going to work exactly as we want it to be.
How old is this legacy program of yours?
Since 1999 I started.
Oh.
Yeah, so this is not new. So the reality is 75% of American families, give or take, haven't done any planning. I think we got this from a Reader's Digest article years ago. I had to probably revisit, see what they have. More comprehensive statistics. But Reader's Digest is very reliable. You know, for a lot of reasons, people just haven't done it. Some people, again, there's a fair amount of people don't have assets that really they would necessitate it. But even if you don't have assets, you should certainly have a healthcare proxy and living will. So people don't do it. Our process on the Legacy Assurance Program is really based on 3 fundamental components. First is to work with a counseling-oriented attorney. We pride ourselves on our counseling skills and our ability to really work with families to get the right result, not from what we would do if we were you, but from what you will do in educating the client about the possibilities. This workshop is the first step in that education, right? You guys come in to see us on an individual basis. If you do so, you're going to be much better ready to hit the ground running than if you just came into us cold. Maintaining a formal updating program. So we have a process where we currently have, I think, about 254 clients, either individuals or couples, who are part of this program, where every year they get notification of education meetings that we do throughout the year in this room, not quite 3 hours, usually about an hour, hour and 15 minutes. We talk about what's happened in the world of estate planning, how the laws have changed, things we've learned, what we're updating our documents, a general overview. And we also do a planning spotlight. One of the things we talked about, and I ran it by clients yesterday, they thought it was a great idea. For 2016, our advanced or planning spotlight topic is going to be what happens if I become disabled or die. Sort of revisiting some of the things we talked about, but people don't remember how the trusts are administered and stuff. A little refresher for people. That's all part of it. The updating program also incorporates getting updated documents on an as-needed basis. Every year we change some documents, some more years than others. So even if you tell us and we send you an update worksheet or planning review worksheet that shows you in a summary, like a 9 or 10-page summary, what your current documents today say, you may tell us, and we have check boxes, yes, make a change, no changes. Even if you say on that form, I have no personally driven changes that we want, we're still going to want you to come in because we're going to have changes that we want to build into your documents that are legal or structural or otherwise, so that your documents are as good today as the people we meet with for the first time. So even if you started with us in 2008, your documents have been updated every year. And we want to make sure that all our planning is done at controlled and fully disclosed cost to you and your family. We're going to go through that now. Now, traditional probate fees, New York follows what is known as the reasonable compensation statute. Reasonable compensation is pretty much whatever the lawyer and the client agree to make it reasonable. Some states have statutory requirements. Florida, Indiana say an attorney will get paid 1.5% of the estate value. New York doesn't do that. Most attorneys, many of them still do a flat percentage. Average tends to be about 3%. So for $1 million estate, it is not uncommon for an attorney to charge $30,000. often they tie it to an executor's commission, which is roughly that amount of money. Under the legacy assurance program model, our fee from soup to nuts, the initial planning, funding, maintenance, and settlement will not exceed between 1 and 1.5% of your total assets. And let's talk about how that looks. So the traditional model looks like this. We have our teeter-totter, we call it. The upfront phase, as we emphasized and pretty clear, is the word processing kind of structure. The cost is pretty low, but the value is low to minimal. There's no funding done. People don't think, oh, okay, we did our basic wills. We've got to sit with a lawyer and talk about how to change our assets. No one does that. And there's no formal maintenance. Attorney gets the will, they put it in the fireproof safe that we all have or at the bank vault, and they sit there waiting until a person dies. And then, by the way, the kids come in or the grieving widow. Attorney says, yes, your husband has $1 million estate, your father has $1 million estate. My fee is 3% of the estate value. That's how it works. Oh, and if we have estate tax returns, which are less common than they used to be, most people farm those out. We do them in-house. And probably the biggest question, are the personal planning goals addressed? Inevitably, the answer is no. We look at all those cloud story questions, and they haven't been addressed. So our model takes a different approach. We take this teeter-totter and shift the value where more of it belongs on the front end. Our design and counseling approach works as follows. We're going to take, our fee is going to be based on 0.5% of the taxable estate, going back to your question from earlier. We have a range, a $5,000 minimum and a $15,000 maximum for foundational planning. So if you come to us and say, I like what you said, but I really want to protect my assets against my own creditors, and I want you to set up one of those Delaware or Alaska trusts, that's not foundational planning, that's advanced planning. But all the other stuff we talked about, the Medicaid and the revocable stuff, that's all generally foundational planning. Now, many times we're just doing either a Medicaid trust for a couple, either joint or separate, or we're just doing revocable trusts. That's all part of the foundational approach. If we're doing a revocable trust and we're adding a Medicaid trust to it, that will be an extra $1,500. Because sometimes people will come in and and they have really good long-term care insurance, they don't need a Medicaid trust. So it's on a case-by-case kind of basis when we deal with that. If we are going to do a standalone retirement trust, we're talking $2,500. That's not per person with a couple, that's per couple as the total fee, or if an individual. So if you're single and you want to get more bang for your buck, get married and we can get you less expensive planning that way. Of course, there will be other costs associated with that anyway. So the range runs from the 5 to 15, and these are just the only really add-on fees that may or may not apply. We do have a funding process. We don't give the client a letter and say, you got to fund this on your own, because that would be really a dereliction of what we need to do. We have a full-time funding coordinator. Her name is Francine Fry, and she does all the paperwork as we discuss. Austin and I or Megan will meet with you individually when we do the planning to figure out how the funding needs to be done. Francine handles the mechanics of it. And we do have a fairly modest funding fee of $65 per funding action. So for those who have 1 or 2 investment accounts and a deed, it's not very costly. People have 20 CDs with 20 banks, that's going to be more costly funding. This often encourages people to consolidate their assets to save on funding costs, which is perfectly fine.
Tends to be a good idea anyway.
Yeah, an average funding cost, I would say, runs between $400 to $600 total. Now, the maintenance fee. We have been, when I started, the first year of maintenance was in the year 2000. All right, that was our first update year. We charged $300 for the maintenance cost for that year. I've been at $400 for a few years, and I've ran the CPI index. We're going to keep it at $400 in 2016. So the increase has been extremely low, and we're just targeting inflation, which has been low, so we haven't had to raise it that much. For the update maintenance fee, you get the things we talked about, the education program, updated documents. We review your funding every year to make sure that what you have still makes sense. And one of the biggest benefits of it is that it entitles you to have unlimited access to any of us for phone calls or emails regarding any estate planning or elder law questions you have without extra charge, which really facilitates the communication amongst all of us. Because clients, inevitably, if we're doing hourly billing, which we do relatively rare of in our practice, if you're doing litigation, you're always getting hourly bills. The last thing you want to do is call me with a question and get a bill in the mail for a charge. That's not going to really encourage you to call us with a question. So by having a flat maintenance fee for that, it really solves a lot of those issues. And then at the end of the day, we know because we've done really good planning up here, we funded and maintained it, we can greatly reduce the cost of the settlement upon death. We agree in advance as part of our fee agreement with the client to a cap not to exceed 1% of the estate value to settle your estate. And the cap is important because that is the top end. We are, especially in cases where we don't have to file estate tax returns, which are fewer and fewer that we have to, the costs go down significantly because the settlement is much easier. If we have all the assets, I can settle an estate in a couple weeks. It could be a $3 million estate. I can knock it out in a few weeks. Costs will be minimal for doing that.
The better planning we do on the front end, the less stuff we have to do on the back end.
Right. It's quicker for your heirs to get their assets in the right way. And so most importantly, cost aside, the personal planning goals are all satisfied. So we think this is a much more applicable, user-friendly, and comprehensive approach that really works for the client and gives us appropriate compensation for our knowledge and our participation. Yes?
The way in your investment accounts, your, for example, IRA annual fee can come out of the account?
Yeah.
Mm-hmm.
Can your estate fund the maintenance fee?
Of course. Oh, wait, the maintenance fee?
Yep. Do you have that?
What do you mean your
the
estate?
Maintenance fee. Can whatever you put together here, can those monies?
Well, we don't invest your money. We don't do any of that.
Right. No, not invest.
You can tell your broker, send them a check for $400, I guess, if that's what you're getting at.
Yeah.
Have it on auto pay, yeah.
Mm-hmm.
So we send the bill out in
Yeah.
January, and then it can be done that way.
Mm-hmm.
You mean
It's
like
not
your
a problem.
trust assets?
Yeah, can you, right.
Well, you're in control of your trust assets.
Yeah, we don't have
so
anything to do with
if
that.
you want to pay us out of your trust assets, then yeah,
Yeah,
absolutely.
we don't administer it like, the broker
Yeah.
or the financial advisors or will take it out of they'll take their own commission. We can't do that.
Right. We're not holding your money here.
That's
We just
right.
take legal documents
Yeah.
and
Right.
you're in control.
But
Yeah.
you answered the question.
Right,
Right.
good, okay.
There are a couple cases, and I won't dwell on them just because of the interest of time tonight, that really show the uncertainty of attorney fees in these uncontrolled estate scenarios. Here's a case from coming up on 5 years ago. There was a big fight amongst the heirs, and the attorneys, everyone had their own attorney. Ultimately, the court approved on a $1.75 million state attorney fees of $300,000. This was in New York City, New York County, which was 17% of the total estate value. What's even more interesting is that, the court noted that the typical fee in an estate of modest size was between 5% and the single executor's commission. So roughly between 5% and 3.5%. Here the attorneys filed a petition, subject to court approval, asking for fees of just under $814,000, which would have been 46% of the estate. So the court knocked them down to only $300,000. I would take that fee.
Every day.
Every day.
Right. Clients wouldn't like it, but
Here is even a lower estate value case, but a much worse set of facts. State of Smith from Bronx, about 4 years ago now. Here's a case. A guy died in 2006, November of 2006. The only asset in that estate was a piece of real estate for about $366,000. The attorney handling the estate, who also done the will, had a retainer agreement with the executor, said that his fee would be equivalent to the executor's commission, which is estimated to be at least $16,000 for one single asset. The agreement added that in the event that the probate proceeding became contested, then he would receive an additional fee of $400 per hour. As I said, the attorney handling the estate was the draftsman of the will. His former secretary is one of the witnesses. Now, Here the attorney failed to prepare a routine document called an affidavit of witnesses that is typically signed at the time the will is signed by the two witnesses, so that if one of them drops dead or they both drop dead, they don't have to appear in court. They just submit the affidavit that is self-proving that they witnessed the signature and that they believe that the testator was competent. So here the attorney did not do the affidavit of witnesses, and when the will was submitted for probate, he could not get his former secretary to sign the affidavit of witnesses. We could only assume they probably had a bad breakup in their relationship, business relationship, and so he or she wouldn't cooperate, whoever the secretary was. So it wasn't until 2.5 years later that the attorney told his client, the executor, oh, by the way, one of your siblings is now contesting it, so now I'm getting an hourly billing for all this. Finally, 2 years after that, the executor fired the attorney. We can only assume for incompetent handling of the estate. Mm-hmm. On his way out the door, the attorney said, oh, Judge, by the way, I'm owed $29,200 for all my excellent work in this case.
The attorney that screwed it up to begin with.
Yeah. The court, against which I think was even ridiculous, allowed him to keep his original retainer of $16,000, which was still 4.5% of the total estate value. But look at the kicker here. As of the court's decision of December 19, 2012, the will had still not been admitted to probate because it didn't meet the statutory criteria of the two witnesses, and the parcel of land remained unsold. So think about, what was the real estate market in 2012 compared to 2006? Better or worse? Worse. Mm-hmm. So the property had declined in value. They're still paying property taxes for all this period of time, and the guy walked off with a $16,000 fee. Yeah. He's the only one who won.
That's thanks for screwing it up.
Yeah.
I'm sorry, wait, 60, you said the court allowed him to keep?
16,000.
Right, right, 16,000 fee, right. Plus, wouldn't the heirs need additional attorney fees to help settle this?
Oh, I'm sure someone else is going to get a fee.
Oh, yeah,
when
there's more money getting paid.
There's more money getting out of this thing. Yeah. So so Mr. Smith on his plat, I can't imagine is very happy with his lawyer's work, right? We want to do a little sample. We are going to go a little over the time tonight because we did start a little later to get people in, so bear with us just a few minutes. We have John and Mary sample in our example here. John is 60, Mary is 58. They have a total of $1 million of assets in 2015, broken up in that way. Assume they each live till age 80. So John lives 20 years, Mary lives another 22 years. Under the traditional model, let's say they meet with the attorney and they do a sort of boilerplate, word processing thing. They pay a total of, say, $650 for the will. Of course, there's no funding and maintenance. If they meet with our process or meet with us, the $1 million estate would call for a $5,000 design and counseling fee based on the 0.5% fee structure. If they opt to do, in this case they did, a Medicaid trust, a joint Medicaid trust, we have another $1,500 fee. Total funding, let's say they had a lot of different stocks that had to be dealt with, was $750, a little higher than normal. And over 22 years, they would pay presumed about $8,000 in total maintenance fees over the course of 22 years, including some inflation built into that. So far, this looks like a better economic deal, I think we'd all agree. Their estate, when John dies in 2035, 20 years from now, has grown to just under $2.2 million based on 4% annual growth. Nothing crazy on that growth rate. John's portion, because he had more of the assets, is about $1.3 million. Mary dies 2 years later. Her estate is just under $950,000. So let's talk apples to apples now. Using a 2.5% probate fee, John's administration, because he owns separate assets, about $33,000. Mary, a couple years later, hers would be a probate fee of just about $23,700. And if an estate tax return was necessary for portability or otherwise, the separate fee is assumed at $5,000. Under our model, even assuming we're at the maximum cap, worst case scenario, a little over $13,000 to settle John's estate, Mary's just under $9,950. Comparing the two numbers, the total planning costs in the traditional model, $62,215. Worst case scenario under the Legacy Assurance Program, $38,000 and change. And which result is going to be better, I'd like to think we know which the answer is for that. So, all that being said, how do we proceed to get to the next level? And this is a question you were asking before. What's our process? It's like a roadmap. Roadmap, first thing is to have the initial attorney meeting with the client. Basically what would happen, and in a minute we'll ask you to spend a few minutes just doing a evaluation form. On there, if you indicate you would like to meet with us, we will then contact you, or Donna in my office, our office will do that, set up a meeting at this point sometime in January most likely. At that point, you come in and meet with us. We do not charge for the consultation. Ordinarily, if someone just calls us to set up a consultation, we do charge $350. So for all you're suffering with us here tonight, you get a little extra bonus. At that meeting, we would have sent out to you a intake worksheet to complete, along with a list of items to bring, your existing planning documents, if any, your financial statements, things like that. And then we'll talk about what your goals and objectives are. We'll talk about the fee structure, which is exactly what we talked about today, so you'll know exactly what your fee would be if you decide to go forward. But at that meeting, you could, at the end of it, say, it all sounds good, but I'm not ready to do this, and that's fine. You're under no obligation to go ahead, and you'll have learned some more stuff. If you do decide to proceed from that, we would then move into our design meeting. We'd set up a 3-hour block of time, at which time we will meet with you either individually or with anyone else you want to have in the room. Some people even get their financial advisor to come, or even their accountants, which is fine. Whatever you want to have there and they're able to come, we'll set it up for them. At that meeting, we'll then go through the whole design process. We'll really ask you the questions. Who are these people in your life? What are they all about? What's their strengths and weaknesses? Who gets along with whom? Who might have a disability? Who might have a drinking problem, or whatever the case may be? And that we get that information. We then take that information and can teach you some more estate planning to make everything work together. Sometimes we don't, this is, it's a little pluralized. We may not get done in one 3-hour meeting. It may be 2, in some cases even 3 meetings. And we're not on the clock. It's all the flat fees based on what it is, so there's no worry about I'm getting billed extra time here. After the design process is complete, however many sessions that takes, we then move into the delivery meeting. We'll have prepared for you all the necessary documents, trusts, wills, powers of attorney, healthcare proxies, everything necessary to make your plan do what it's supposed to do. And we'll review it with you, whether it's me, Austin, or Megan. We'll sit there and review those documents with you, make sure you're comfortable with them, and have you sign them. At each meeting, we're scheduling our next meeting. You're then going to get into your funding meeting. By this time, we'll have received all your account statements and otherwise, and we'll sit down, one of us will sit down with you to discuss, okay, this should go into this trust, this should go in this trust, who's going to be the beneficiary of this? Are we doing a standalone trust? If we have one, we're going to name that as the beneficiary, and that's a very comprehensive process too. Then when the documents are prepared, Francine will prepare the funding documents, you'll sign them, and then you're sort of on cruise control. We would have, as Austin said, we could have that family team meeting if it works for you. And then we can have and then you'll be fall into the maintenance program. Many people, that's all they ever need is do the maintenance for the rest of their life. Occasionally something more dramatic will come on and they'll need to meet with us before their regular update meeting, and that's on costs are on a case-by-case basis for that kind of thing. And then ultimately your plan will mature, either become incapacitated or you pass away, and then we implement the settlement process that we just talked about. So I think one of the real values of this is you never have to worry about, is this the right time to do my estate plan? Because with us, it's never really done, right? It's always being tweaked and modified, so you never have to worry, oh, if I do it now, what happens in 5 years? We got that covered. It's all covered, right? And that's really, I think, a very valuable planning tool.
What was that in between the annual maintenance and the settlement upon death? That was, you said that other charges would apply?
Oh, well, if you call us, if you had to make a dramatic overhaul of your plan.
Like you rebuilt a house in another state?
No, well, not so much that. More so like you set up for a child a liberal trust because they're perfectly competent. Then you find out they have an addiction issue. We have to have a counseling session to really talk about different ways to provide a more protective structure. Okay, so anytime you really have to tap into our brain a little bit, right, we have the right to charge.
Like if a daughter gets married and they have to change her last name,
that doesn't
we don't
cost
think
anything
about that, right?
Okay.
But if we really need to change a substantive part of the planning,
Correct.
that we really should talk about it. you
Right.
know.
And we bend over back. We have very good long-term relationships with clients. We've been doing this. I've been with some for now 16 years, and they know I'm going to treat them fairly, and they're going to treat me fairly. It's a two-way street.
As far as your estate planning services, the legacy program is the only option.
Not necessarily. This is the one we
Just
strongly
just
recommend.
theoretically.
If someone says, you know, we want to do this, but we know we're going to move to Florida in 2 years, so doing the whole maintenance really doesn't make sense. We'll do the same upfront planning, but we'll have a little different structure on the fee, a little bit lower upfront fee, because we know we're not building in all the maintenance over the years. So that's a very good question.
If you started out that way, could you move into the legacy then?
You could,
allowed
but
for-
technically we'd probably charge you for all the years you didn't pay, you know, that you should have been paying. We don't want people backdooring in, oh, I'm on my deathbed,
Yeah.
now I want you to update my plan and be part of it. So it's got to be fair.
What if you're moving to a different state?
I'm sorry?
Within the next 4 or 5 years, you plan to move to another state, would that affect?
Well, that's something we would talk about, whether you want to go that route or not. We have relationships. We're part of a large national organization called the Wealth Council, and also its sister company, Elder Council, that provide us not only with all the software we use for our planning, but also there are over 2,000 attorneys nationwide who are in these organizations who we can and do refer clients to, many of whom do have maintenance programs similar to ours.
Well, we could still meet with you, I mean, but different states have different laws.
Oh, that's true, yeah.
That's my concern. Yeah, like Pennsylvania.
Well, we're licensed in
Well,
Pennsylvania.
both
We
of us are
can do
licensed
that.
there, yeah. We're licensed in Jersey, too.
Jersey,
That wouldn't
Pennsylvania.
affect the plan,
No.
you made it now?
No, we would tweak it if you moved to
We have a
Pennsylvania.
handful of clients that actually have moved to Pennsylvania, and
We've changed their documents to Pennsylvania documents. It's not very hard to do. So anyway, without taking up more of your time, if you have other individual questions, you can do that. But we will ask you in your packets here to spend just a couple moments under the workshop evaluation on the left-hand side of your packet. Yeah. If yours has a couple, you can do one. That's fine. Yeah.
right.
On this form, we do ask and we do look at your comments. We take them to heart, and if there are things that you think we should change, we'll do that. And on the second page of the form, you'll notice there's a section if you have other topics you're interested in. And then in the middle of the page, the next step. This is where you would indicate in the event you would like to meet with us. You would check the yes box, include a daytime phone number. I don't ask Donna to call at 10 at night. And then we'll contact you then. If you say you're not interested in hearing from us, by all means, we will not stalk you and bother you and solicit. That's not what we're here about. We think, we provide, I think, a valuable service, but it's not always the right time for people. It's just not for them, and that's perfectly fine, too. So that's really what we got. If there are other people you think might be interested, by all means, we do these workshops every month. We have January, February already scheduled, and I'm sure we'll be scheduling March through May probably fairly soon. So without anything further, we want to give you a chance to fill this out. We do want to thank you for taking time from your busy lives this holiday season to join us. And if you are interested in meeting with us individually, we'd be delighted to see you. If not, we're happy you came in any event. And we wish you happy holidays and a very happy new year, too. Thank you very much. Great. Thank you.